BP for receipt. My lord, item number 8, I pay commission, my lord. And gets
Hmm?
council, my lord.
Just one. Item
Any
number
date, my lord, next week. Item number 8, my lord.
11.
8,
What is it?
please. Any date, my lord, next week, my lord.
Huh?
Any date next week, my lord, kindly accommodate.
Item number 11.
8,
11, 12, 13.
8, 8, my lord.
Item number 8.
Yes, my lord.
The request of the learned counsel for the petitioner. Matter stands adjourned to be listed after
Next week, my lord. Next week, any date, my lord.
4 weeks.
Applies, my lord. With regard to item number 11 to 13, my lord. I'm led by senior counsel, Mr. K. Mishra. He is unwell, my lord. He is unwell. My lord, he suffered from dizziness and he fell down in his bathroom. He was also hospitalized. He has been advised to rest, my lord. Maybe
He's only in there in item number
item
12.
number 12, my lord. In item number 11 and 13, Mr. Kejriwal is there. He is out of station. His letter of absence is also there, serial number 5 and 6. He has requested me to inform.
Item number 11 to 13 to be listed for 4 weeks.
Okay, thank you, Lord. First, I'd like to mention item number 17. My senior counsel is out of the station also, and I have also given leave application
Hmm?
accordingly.
What is this matter about?
Also, this matter is about land acquisition
And
by the NHIDC.
why do you want an adjournment?
So, Lordship, my senior counsel is out of station. He has a matter in
Who is your senior counsel here?
Advocate Manas Sarania.
When did he get the designation?
Lordship, my senior counsel.
Or senior? Okay. Item number 17. The request of the learned counsel for the petitioner matter stands adjourned to be listed the 6 weeks.
Much grateful, Lord.
Is there any interim order, Mr. Counsel?
I think to mention, my lord, item number 15, my lord. My lord, matter is infrastructure, my lord.
The L.N. Dehinia, the learned counsel appearing on behalf of the petitioner, submits that the petition has become infructuous. Accordingly, the petition stands closed. Interim orders, if any, stand repeated.
Master, sir.
Top of the list, item 18 to 21.
Dr. Todi, which matter is yours?
My lord,
Which matter is yours?
item 18, my lord.
Name, number?
Muslim Bhuiya.
Mahate Bhuya. Okay. Let us see one thing. "29" is the provision, isn't it?
Consensus of registration, my lord.
Where is the prescription, Dr. Rod? As per the rules?
My lord.
Where is the prescription as per the rules? Because everywhere it said
मतलब इनके रूल 22 मतलब जे रूल कहीं के रूल मतलब रूल 23 मतलब speaks about a revocation cancel registration.
kindly come to rule 21A.
Rule 21 मतलब the registration granted to
This is relevant because what is happening, the day they suspend, they issue the show cause notice, on the date they suspend it also. This is also an aspect which requires to be taken note of. Where the proper officer has reasons to believe that the registration of a person is liable to be cancelled under section 29 or rule 21, he may suspend the registration of such person with effect from a date to be determined by him, pending the completion of proceedings for cancellation of registration under Rule 22. And a comparison of the results in so and so.
but it is 6 my lord. In my lord 21 A speaks of simile 6 my lord. But here is a case my lord.
Now, Rule 3, sub-rule 3 says, a registered person whose registration has been suspended under subsection 1, subrule 1, or subrule 2, or subrule 2A shall not make any taxable supply during the period of suspension and shall not be required to furnish any return under section 39. So therefore, he cannot file his return. Now, the second proviso says, provided that where the registration has been suspended under subrule 2A for contravention of the provisions contained in clause B or C of section 2 of subsection 2 of section 29, and the registration has not already been cancelled by the proper officer under rule 22, the suspension of the registration shall be deemed to be revoked upon furnishing of all pending returns. So during the suspension, how do you read rule 3 with the second proviso of rule 4?
My lord, so far, my lord, my understanding is concerned, my lord.
Now, kindly see 22.3. This is also very relevant.
22C. Where a person who is submitting a pension. No longer. In fact, my lord, if you look, see, my lord, my understanding, my lord. But 20A, my lord, we don't fall in, my lord, 20A, my lord.
No, 22.3.
My lord, it's again, my lord, where a person who has submitted an application for cancellation of his registration.
No, more. Is no longer to be registered or his registration is liable to be cancelled.
Yes, my lord, cancel.
The proper officer shall issue. There are two aspects. One, when he voluntarily comes or his registration is liable to be cancelled. That is under 29.2. The proper official shall issue an order in form so and so within the period 30 days from the date of application submitted, that is voluntarily, or as the case may be, the date of reply to the show cause notice under subrule 1 or under subrule 2 of rule 21A, cancel the registration with effect from the date to be determined by him and notify the taxable person, directing him to pay the area of any tax interest, including the amount liable to be paid under subsection 5 of section 29. So, isn't it required for the officer at the time of cancellation to quantify the amount as per him? What is to be paid at that point of time? Because this is a very important aspect.
Right.
Because from there, he cannot thereupon make the payment. He cannot file his returns. Therefore, you see why I was showing, if he is suspended under 21A3, a register whose registration has been suspended under sub-rule 1 or 2 or sub-rule A shall not make any taxable supply. So it is stopped during the period of suspension and shall not be required to furnish returns. Therefore, he cannot, the question of furnishing returns under 39 does not happen.
But my lord,
The reason seems to be in view of 22(3), which categorically say that you are to specifically state what is the amount due. If you don't say that, because the problem later on will arise otherwise, then how will he file his return?
correct, my lord.
As regards input tax credit, everything. Therefore, you see again coming back out here to section 29,
29, but there also
29.
it's incorporated, my lord.
Huh?
That outstanding dues has to be determined and has to be paid, my lord. 29,
Therefore, if you see
29,
section
perhaps
29
we-
again,
29, my lord.
kindly see
subsection
section
3,
29(5).
subsection 3,
No, 29(5).
yes, my lord.
Every person whose registration is cancelled shall pay an amount by way of debit in the electronic credit register or so and so equivalent to the credit of input tax in respect of inputs held in his stock and inputs contained in the semi-finished good held in so and so. So he has to do this. So as regards input tax credit, it is input tax. This aspect has been taken care of by 29(5). As regards the earlier amounts which is required to be paid, for which the registration has not happened, that has to be quantified and stated in the order.
Yes, my lord.
Now, what they are doing is they are mechanically passing these orders and saying that you make the payment. This has a consequence later on when you go for again revocation of that. Revocation of the registration, the cancellation,
Well-
then the problem otherwise arise, which has arisen, just for example, arisen here. But how do you quantify later on the amount if you have not already stated that? Therefore, you see, this is why
Officer has to quantify, my lord.
quantify. You see this. Cancel the registration with effect from the date to be determined by him and notify the taxable person directing him to pay the areas of any tax so and so, including liable to be paid under subsection 5 of section 29. So he has to notify. He cannot just make it say that you pay.
Yes, my lord.
Where the reply furnished under so is found to be satisfactory, provided where the person, instead of replying to the service served under sub-rule 1 for contravention of the provisions contained in B or so and so, man furnishes all pending returns and makes full payment of the tax dues along with the applicable interest and late fee, the soul shall drop. So if during the pendency of the show cause notice, if you make the payment, it is dropped.
Yes, my lord.
The provisions of the shall apply to all legal heirs of so and so. Then again, you see for revocation, another very important aspect, there are various tiers. First, you see, once you file the application for revocation, they have to give you an opportunity for hearing. And if they feel, kindly see this, a registered person whose registration is cancelled by the proper officer on his own motion may submit an application for revocation to the within a period of 90 days from so and so. Provided such period on sufficient cause may be shown and for reasons to be recorded may be extended by the commissioner or his so and so. Whether is satisfied for the reasons to be recorded in writing that there are sufficient grounds for revocation of the cancellation, he shall revoke the cancellation of registration by an order in so and so within 30 days from the date of receipt of the application and communicate. Then you see the most important. May for reasons to be in writing under other than those specified in A, in so and so reject the application for revocation and communicate the same to the applicant. Shall before passing the order under B issue another notice. Therefore, again asking him to apply, taking into account the far-reaching consequences of cancellation of our registration has.
my lord.
You see, for reasons to be recorded in writing under so-and-so, other than those specified in so-and-so, reject the application for revocation of a cancellation of registration and communicate the same to the applicant. The proper officer shall, before passing the order required under B of sub-rule so-and-so, issue a notice under Form GST REG 23 requiring the applicant to show cause as to why the application submitted under should not be rejected, and the applicant shall furnish the reply within a period of 7 days. So, upon receipt of the so-and-so, information or clarification in the proper shall proceed to dispose of the application in the manner in sub-rule 2 within a period of 30 days from the date of so-and-so. So this is how the manner it is. Now, what is being done out here is just you don't file, they cancel it, it goes. And you did not submit a reply.
What happened? What we have stated in our petition, my lord. In fact, whatever it has been uploaded, what a notice was uploaded in the portal. My lord, since my lord, the time during the pandemic, my lord, because it was during the pandemic time, my lord. So what
No
happened, my-
pandemic, no, Mr. No, Dr. Tudi, kindly don't say pandemic. 6/11/2019 pandemic did not come.
Lordship will kindly aware of the
No, no,
situation.
no.
In fact,
Yes, it was there in Wuhan, but we can't expect it
but
anymore.
the other thing, but the petty payment, don't think for 3 years, my lord, only 68,000 was the liability, my lord, which is paid in my lord, March 2024, my lord, of his own. Petitioner is only of his own, my lord. But what happens in this case, my lord? What happened, my lord? Suppose, my lord, because he is not a my lord, very big businessman, he's already keep track of the portal, my lord. But when he missed the my lord, he didn't supply, my lord.
But another thing is, the revocation cannot happen without you filing all your returns also.
My lord, true, my lord. Under rule 22, it's 23 says, my lord. That, my lord, I'm coming to that, my lord. Before that, my lord, lordship might permit me, my lord, to submit only few aspects of the matter, my lord. In fact, what happened, my lord, if you lordship kindly see the notice, my lord, check the notice was there, my lord. It is the notice is a facsimile of the, my lord, it is the rule itself, my lord, rule itself, the format, my lord. If you lordship kindly come to page 19, my lord, for time being, my lord. In fact, my lord, what happens? Last below, my lord, this is the first number one. Any taxpayer other than composition taxpayer has not filed return for the continuous period of 6 months. That is, my lord, in the format itself. But he used to specifically mention for how many years, how many months return was not filed. Still, my lord, we ignore it. Let it be, my lord, let it be. But second is very interesting, my lord, very important. My lord, you are hereby directed to furnish a reply to notice within 7 working days from date service of the notice. Then, my lord, last is very important. If you fail to furnish a reply within stipulated date or fail to appear for personal hearing on a appointed date and time, the case will be decided expertly on the basis of available records and on merit. My lord, in fact, my lord, this, my lord, to my understanding, my lord, in simple understanding, my lord, even the, my lord, the my lord, the legislature wanted date, my lord, you have to fix a date also, notify the date and time, and venue, my lord. But that is also absent. My lord, in fact, my lord, it is not a hollow formality, my lord. It's substantially complied with, my lord. Then reasonable opportunity as per the intention of the legislature has to be given. But which is absent in this case. Then, my lord, abruptly, retrospectively, my lord, then, my lord, from the date after waiting for 7 days, my lord, then subsequently, my lord, immediately the residence cancel. But option for revocation is to, as per rules, within 30 days after the cancel of registration, my lord, which I missed, my lord.
Huh?
Because that as per rule says that after cancellation within 30 days, my lord, the application has to be filed for revocation of the cancel of registration. But my lord, I missed the bus.
No, no, Dr. Todi, why I am going into deep into this matter
My,
is to stop this coming of these matters before this court.
but to my lord.
So it could be resolved there.
My lord.
In fact, I could go through a GST cancellation circular, how it is to be given, how the revocation of a license procedure for calculation. Have a look at this. I think it gives a better understanding. Hey, Hunoksun. You
The
take it
Lord
up,
Smith
please.
already, my lord, decided the cases, similar cases.
No, 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 no.
And
In
said
similar
this was-
cases, they have restored it. You see, the restoring out there every time does not make a sense. One has to
Quite true,
stop this
quite true.
problem.
Has to streamline for.
Yes, you
one
see
step
this, how it is to be cancelled, it has been categorically mentioned out here.
My lord.
And how the revocation applications are required to be taken into is also to be taken into account so
Quite
that
true, my lord.
the effective, the remedy which is there is very effective. But the problem is that the officers are not doing it in a manner. So this requires to be properly set out so that these are
Correct, but-
every time, because one thing one has to understand, once there is a registration is there, registration is cancelled, it is almost like a debt to a business because he can't either get any supply or anything out there, he can't get anything. What he can do out there, his only recourse is for going for a return, what do you call, either he has to forfeit everything and go for a fresh registration. Now, if it is a fresh registration, how do you calculate the amount?
Quite true.
Therefore, the requirement of 22.3 categorically mentions that you have to specifically say what is the amount.
Right.
Now, in your notice at page 20, if you see the order, they say that there is nil liability.
On the cases, final liability is not shown.
So there is nil liability. So what is the problem in giving a fresh registration also him?
In fact, my lord, that is. so
This
far-
is a very important aspect. If it is a nil liability, what is your problem? Is it to submit the nil liability return?
Others also, my lord, as per.
You may cancel very well that he has stopped his business.
others
He is
also-
not carrying out his business. But that is not the reason. In your notice, the notice is that he has not filed his return for the 6 months.
The case of article, rule 22, that is relating to suspension of registration. But here the case in your.
No, no, no. Rule 22 is not suspension.
Cancellation of registration.
Ah. Suspension is 21 and 21A.
Quite true, my lord, where it is there, my lord, in fact, my lord, as per my lord's, subsection 3 of section 29, my lord, in spite of cancellation, my lord, he is not, my lord, absolved from paying his liabilities, past liabilities. Which past liability has to remain, he has to pay. Along with the, my lord,
And
interest.
thereafter, therefore, I'm saying, if we see 21A3, it categorically mentions that he cannot file his return.
Yes, my lord.
So it is stopped from there.
Yes, my lord. So, my lord, return means, my lord, pay.
So
return-
therefore, you are to adjudicate how much amount is to be payable from them.
They have to remain.
You cannot just give that, okay, you pay whatever it is. In some cases, it may
Has
be
to
like that.
determine. Determine interest as well, penalty as well, if something. is-
Absolutely, everything is required.
In my case, but central is the no party. I think this is the party. But he is helping, but his inputs will be. But in my case, central GST is not the party, but still, my lord, his inputs will be. My lord, central GST is not the party in my case, my lord. But still, my lord, his inputs may, my lord, will help. The one or both.
But he is in some cases,
In other
he is.
cases, my lord.
Some cases he is there.
Yes, my lord.
The
Other-
format are almost same. The central GST and state duty.
This is, my lord, in fact, my lord, continuous with 29.3.
Here in this case, Camray Engineering Service Limited, there is no reason.
In fact, my lord, what was rightly pointed out, my lord. In fact, my lord, this is the in fact, the crux of the matter, and this is the crux of matter, and but on the other day also, Notes will set right to the many issues, complicated controversial issues, my lord. This time also, my lord, it will be helpful to everyone. and
Everyone, so they do not, kindly see, Dr. Todi, the aspect pertaining to revocation. The revocation, so that people will go there and find out and do the revocation out there, because they don't have to come to the High Court. And then the revocation becomes an effective remedy.
Revenue should not be affected, my revenue interest of the state, my lord, that should be affected. And my lord, contained in subsection 3 of section 29, that in spite of cancellation also, my lord, he is not absorbed, but he has to pay. All his return, my lord, may parade the case. The cancels for registration under this section shall not affect the liability of the person to pay tax and other dues under the act, or to discharge any obligation under this act, or the rules made thereunder for any period prior to date of concession, whether or not such tax or other dues
So
are
therefore,
determined.
no, therefore, you see, therefore I'm saying 21A3 says that once you are suspended, you cannot carry out any taxable supply.
Yes, my lord. Cannot.
Then it further says that if you want to be, you have to get it revoked. 22, 3 categorically says that when he gives it, the cancellation, he has to say that this is the amount you are to pay in this manner. And then 40 says that you are therefore required, section 40 says that you are to file your return within a particular period of time. So this is how it is.
Yes, I am obliged, my lord. This is the my lord in
So
fact.
this is the manner in which everything is being done up. So all these things have to be taken up together, and then I think the proper recourse has to be given. Merely by asking you, okay, cancel it, he will do it. This is not going to solve the problem unless we pass an order to the effect that these are the parameters which requires to be followed. Maybe because of the fact that these forms are written in such a small manner, it may not have seen through the thick spectacles these officers use. If you see GST, REG 17, Dr. Toby, you'll
Well-
find you are hereby directed to furnish a reply to this note within 7 days. You are hereby directed to appear before the undersigned on so and so. Can you see that? See the form in this book?
This is wrong.
Where is it in the notice? Mr. Chaudhary, where is the notice? Page 19. You are to give the form in this manner. The form categorically says, you are hereby directed to appear before the undersigned on so and so at so and so hours. So if the registration notice is not in GSTR, GST REG 17, wouldn't that be in contrary to the rules? Do you have the book?
Yes, ma'am.
Come to that page, GST REG 17. I think, Dr. Todi, have a look at this.
Well-
I think in my judgment, I want to incorporate these aspects so that in future, there's less of problem for the people.
Quite true, my lord. Yet, my lord, otherwise also after concession, but he cannot raise any bill because he has to raise bill with GST to collect and deposit in state exchequer. So if his registration is cancelled, how can he raise bill? So all the pending matter remain as it is. So state also deprived of the legitimate revenue, which it should have been derived. And the businessman also is suffering because of whatever. So, my lord, to have a balance in that, my lord. So
That
that
day, Dr. Todi, I was reading a judgment of a learned single judge of Patna High Court. Why I am saying this is in context of what you are saying. In Bihar, there is a ban on liquor.
yes,
You have read the judgment. What is happening? It is the state which is losing as per the judgment. While other people have been getting the benefits. Because the liquor is otherwise flourishing, otherwise there would not be lakhs and lakhs of cases. So the fact that there are so many cases means there is the prevalence of liquor out there, which is otherwise bad. So the state is otherwise losing.
So that's what target is also fixed. Target is also fixed, my lord. And that's why the Bihar, my lord, what they said, because they said that because we said that liquor word will be changed to the other word, so that my lord, it does not follow the parameter of liquor. This is very, my lord, different issues were came up after the ban, my lord. This is also, my lord, because also, my lord, if they pay the tax, and my lord, for conformity with is Rule 23, my lord, that can be again, my lord, can be revoked at in terms of the honorable court, my lord. My lord, this is the, my lord, in fact, contained here also. In the, my lord, this is the Finance Act 2024. Lord, see, may can be have a because there also, my lord, if the tax is paid and the interest is paid and my lord, the penalty if something is there is paid, even after consumption can be revoked at in terms of the honorable court.
Which one?
Section 118, my lord, page 38, Lord, see, may can leave 15. Is see, my lord.
New
Page
amendment,
58.
section 66, I think it's
118, 118, my lord. This integrates into input tax credit, my lord.
No, this benefit is being given.
Yes, sir. So that is, my lord, what Lord C was intended, my lord, perhaps, my lord, it was correctly said, my lord. So it is the, my lord, we solve the problem and set it right. My lord. Many issues. And the mistake will get it legitimate revenue, my lord.
No, it is for that person concerned.
Right.
He can take the input tax credit.
Right.
That is it. He can very well take the credit. But the question is, first of all, when you are issuing a notice under Rule 21, Section 29, it is mandatory that you have to do it in GST or GST 17, REG 17. It categorically mandates hearing.
Well, here, my lord, my
And nobody in these cases have gone for revocation.
in fact, my lord, because 30 days was left, my lord, missed the last.
No,
And
you
it
are
is
there,
over.
but other.
not a lot. Is 747.
So what happened to your revocation?
I returned my lord. I went in the portal and I tried to application for revocation. The message display my lord. Time limit of 270 days expired. Now you cannot go for revocation. But I have annexed in my decision.
Now kindly see what happens to, kindly come to section 30. No, rule 20. 23. Revocation has to be made within 90 days.
Yes.
A registered person whose registration is cancelled by the proper officer on his own motion may, subject to the provisions of Rule 10B, submit an application for revocation of registration in form so and so to such officer within a period of 90 days from the date of service of the order of cancellation at the common portal either directly or through a facilitation center notified by the commissioner, provided that such period may on sufficient cause being shown and for reasons to be recorded be extended by the commissioner or an officer authorized by him in his behalf, not below the rank of an additional commissioner or joint commissioner as the case may be, for a further period not exceeding 180 days. So that means 270 days. 90 plus 8, 180. Further, that no application for it shall be filed if the registration has been cancelled for the failure of the rate to furnish the returns, unless such returns are furnished and any amount due as tax in return in terms of such returns have been paid, along with any amount payable towards interest, penalty, and late fee in respect of such returns. Now, this second proviso comes into wherein you categorically say how much amount is to be paid. Now, if there is no amount payable, as in the case of Dr. Todi's case at page 20, you will find there is no amount to be payable. So that proviso, the second proviso would not apply. All returns due for the period from the date of the order of cancellation till the date of the order of revocation of AR shall be furnished by such said person within a period of 30 days from the date of revocation. So after the date of order of revocation, within 30 days, you have to file your returns. Is permitted. So this is this. Also that all returns due for the period from the date of order of cancellation of the registration till the date of order of revocation. So that entire period, like for example, the Dr. Todi's case, from date of cancellation to the date of revocation or the setting aside by date, shall be furnished by said person within a period of 30 days from the date of the order of revocation of cancellation of the year. So, Mr. Mishra, tell me one thing. On the portal, it is not possible. But on the portal, is there any what you call any way by which you can ask for beyond 90 days?
Take the vote. It is take the vote. Beyond 270 days, it cannot be.
Huh?
For 90 days, my lord, there is an option comes, my lord, which says reasons why it is delayed to mention there. But 270 days, there is the portal doesn't allow. And enter into the end of revocation.
So your case is beyond 270 days. So the power is not there after 270 days.
So looking at the mallet, let's say for other, let's say in the meantime, the scheme was launched under 648, fixing date 31st December 2022 to file application for revocation. And that was extended up to 30th of June 2023.
20?
23. That window was open to all the SSC. And during that time, lots of many SSC file application for revocation, their application was considered. The extension
No,
notification-
but if it is beyond a further period of not exceeding 120 days, if it is mentioned out there, then under such circumstances, can you can this court also exercise the jurisdiction beyond that period?
226 or six, probably under 226 or six,
How?
any high court's pass order revoking the cancellation, citing the region of natural justice. And
The natural justice, if I have to strike that first order itself, that is one thing. But a question arises, how do you take care of the judgments of the Supreme Court in the respect to Arbitration Act 34
probably this court has no jurisdiction.
No, beyond
Beyond
34 the period having been mentioned to be 120 days. They cannot be under no circumstances, even in the case of Commercial Courts Act, you cannot file your written statement beyond 120 days. Because it is used that not further extending this.
There are judgment with respect to central excise also. The court has no power to extend time limit provided in that.
But if the initiation is in fact bad, then
Then probably also can.
it would come within the exceptions of the Godrej Sarali. Then he need not go for a revocation. So he can come very well here.
Correct.
Isn't it?
He has to come within the period of revocation.
No, therefore, Godrej Sarali says there are four ways. One is jurisdiction and all. But if it is in violation of principles of natural justice,
Then
then obviously one can come in.
question of alternative remedy. Whirlpool, Puja the Puja.
There are some judgments of Delhi High Court. What they are doing is they are condoning the delay
Yes, sir.
and directing them to move applications under for revocation.
Yes, that is some. I
That
could
is
say.
the mostly the trend.
Yes.
Instead of this court doing.
Madras High Court has observed something other laws.
Madras High Court also have done the same only. Has gone into the question of natural justice. It has looked into the question of small traders and all.
Yes,
This is the
that,
problem which is being faced
but
and all.
It's a not.
And all these
death
things.
penalty,
And
but it
Madras
was-
High Court had made a request out there that kindly consider the revocation.
Yes, Lordship, it is.
That is what have been stated by Madras High Court. But normal trend is to take care of this limitation of 270 days. And thereupon ask them to go ahead with the question of revocation, how it is to be.
Most cases are being remanded to the authorities on the that delay.
Most of the cases, it seems like that.
Determine the malus tax. To determine the tax malus within a time frame, the tax will be determined, interest and then if they pay, then malus will be go. That's
No,
correct.
no, because the moment your application is being filed, they are bound to take within the ambit of the time which is there. I need not say.
Yeah.
Section Rule 23 also categorically mentions when. And even says that if they are of the opinion that not to be given, then also it is the case that you have to be again issued an explanation as to why it is so. But these are not being done, no?
Tax malus,
In 21-22, about 3 lakhs registration has been cancelled. When the SCC were facing problem, then this scheme was launched under section 158. Initially, it was up to 31st December, then it was extended to another for 6 months.
So first you file 29 happens, 30, 107, then here. Isn't it? Hearing complete judgment results. I'll, Dr. Todi, I would not like to just pass the order like this. I'll put it on a more detailed note. I think this will help later on so that the people.
Yes, my
will-
lord.
I'll allow these repetitions. All
Much
these
better.
repetitions will
Much
be allowed. But I think the allowing would be by allowing you to file an application for revocation by condoning the period. And they will consider duly. And I think some backdrop needs to be given that it has not been done. But however, when that forum is there, I'm not exercising by condoning the.
But one small prayer is there, my lord.
Huh?
One small prayer.
Yes.
But this is, my lord, in fact, my lord, Lordship may kindly lay down the law, my lord, because which is silent and, my lord, this is creating lots of
No,
complications.
that is why.
That, my lord, that notice should not be hollow formality, my lord, that a hearing has to be given, my lord. But without it, this is not hollow formality, it's happening, it's just giving a notice, my lord, in the portal. But they cannot wash their hands. So, my lord, if they want to be effective reply, effective, my lord, decision they want to take, then it has to be effective, my lord, that hearing has to be given as contained as the intent of legislation, my lord, that should be, my lord, a hearing should be given, date should be fixed, and time should be mentioned, but not that, my lord, simply giving that. But
No,
Lordship
no,
will lay
that-
down law, my lord, it will help to. Perhaps which is silent in this line, my lord.
No, Dr. Lodi, I have understood that. That is why I'm saying this is this thing which I've given it to you. I think these are the things which needs to be laid down as a guideline.
My lord.
How it is to be proceeded. So that you don't get every day you don't get these type of cases here. It is
Yes,
not
ma'am.
required. It would have been very well done. And in fact, as I told you on earlier occasion, the act and the rules have been made very well.
Yes.
But the fact that the officers are not following is the reason.
See, another thing, the form, REG 17, it was amended in 2022. And you are hereby directed to appear before undersigned on date is mentioned. There it was not there.
Date time is mentioned.
Time is
Yes.
also mentioned. But that is amended in 2022. That come into effect from 26/12/2020.
They don't follow.
Lordship, but
They don't follow.
in item 21, right, it's a matter of 21 before that amendment was made.
No. What was inserted in 2022 is kindly refer to the supportive documents attached for case specific details. That line was inserted in 2022.
And what is the note? Footnote. That was, your residence state suspended with effect from so and so.
No. This was only inserted. You kindly see in this book, I don't know your book, kindly see this book categorically shows that. Only that line was sought to be. এই তেওঁলোক ক'বচোন আৰু এখন নতুন এখন কিতাপ আহিছিল ল'ব লাগে।
Is some, my book is written some.
Here it only says for supportive documents was brought in 2022, not the, because otherwise, how do you read the next portion? After that,
Yeah.
how do you read that portion? If you fail to furnish a reply within the stipulated date or fail to appear for the personal hearing on the appointed date and time, the case will be decided ex parte on the basis of available records. Kindly refer to the supportive documents attached for the case details. This was brought in 2020.
It was, yes, you are kindly referred to supporting documents.
And another thing is where the proper officer has reasons to believe so and so, they are requiring him to show cause within a period of so and so as to why it should not be in case here has submitted an application for cancellation of the year or within the 30 days from the date of Iman, directing him to pay the area they have and reply has been furnished and responsible. Where the person instead of replying to the notice on the air for contravention of so and so for clearance of the students. You see, 29B2, 29(2) proviso. Provided that the proper officer shall not cancel the registration without giving the person an opportunity of being heard.
My lord, uploading in portal is not a notice served to the person, my lord, and a fundamental right to carry on business cannot be taken away by uploading in the portal, and my lord, the response is over. So my lord, that has to be, my lord, but proper portion hearing should be date, time, fixed, everything should be mentioned, my lord. My lord, this law should be laid down, my lord, in this land, my lord.
Now, issuance of a notice in the particular form, would it mean uploading in the portal? I think so. There was something which I dealt with on the last occasion in that notice respect.
TRC one case.
Huh?
TRC one case
Huh?
that relating to state gist. Yes. But,
Uploading in the portal.
but there are some judgments where it says that, after the scheme of the act, some notice is uploaded on the portal. There's a duty of the SCC to go through to open the portal. Cannot take plea that I have not opened the portal, so I am not aware.
Because somebody said, I have taken care in that judgment, I suppose. Somebody made a submission to that effect that how will I know what is there in the portal? Then I said, then no, nothing doing because, but the fact that the DRC is a document which is submitted along with the notice.
Yes, that is.
There's a difference between the physiology of this and 149. Kindly see 149.
There is a circular to that effect that, DRC is to be issued along with.
49 or 151?
Lord, may kindly also see, my lord, section 169.
159.
169, my lord, 169, my lord. Close A, section 1, close A. And section 169 says, my lord, any decision.
Any decision, order, summons,
order,
notice, or remand as the
summons,
rules
notice,
shall be served by any one.
Application under this act or the rules made under shall be served by any one of the following methods, namely by giving a or tendering it directly or by a messenger, including a courier to the addressee.
By making it available in the common portal. See that. 169 1D.
by registered post, or speed post, or courier, which acknowledges due to the person to whom it is intended.
No, Dr. Todi, kindly see in by served shall be served by any one of the
Making
following
available to
methods.
phone portal. But it is, my lord, it is, my lord, in addition, but if Lord CB can't
Not,
see.
not addition, not addition. The question of addition does not happen. Shall
no,
be
for me,
served
but-
by any one of the following methods.
My lord, here, my lord, here, my, that's what, my lord, I was.
Dr.
submitting-
Todi, you are not challenging the virus of 169.
My lord, what I am submitting to Lord CB, my lord. Who, my lord, but if the, my Lord CB can't really see, my lord. My lord, if the, my lord, the date, time has to mention, but suppose the portal, on the portal, but even the notice was silent to the date mentioned, it did not mention date, time, nothing is there. They only the, everything is there. But the date is not mentioned even in the portal itself. That is the, my lord, so far the defects in the notice itself, I am pointing out. So far my case is concerned, but that apart, my lord, if lordship can looks into the matter, my lord. But here is the case, my lord, that's why we are before your lordship, my lord. There are 226 lordship, we can see what is fair, which is unfair, and what is reasonable, and to what extent, my lord, one is expected to discharge his obligations, and my lord, is intended by the legislature. But here is the case, my lord. My lord, if I want to ask question to myself, my lord, suppose I am not, I am a very big businessman, my lord, am I not right, my lord, my right to get a notice from the authority, my lord, in that case, my lord, supporting, I didn't open the portal for quite long period. I missed the pass, my lord, within 7 days I am to reply. So, my lord, what is remedy available to me, my lord? But here is the case, my lord. So that's why, my lord,
But we are, you are not challenging 169.
in fact, my lord, but if he lordship, my kind of, but that is my prayer before lordship and submission, my lord. So that, my lord, intended, but in addition, but lordship may kindly miss, my lord, in the
No, this I could have made if it was similar to the language which is given otherwise. See, like a order which is passed on the 73
that, my lord,
is, it will be in the DRC portal and the order has to be also separately made. Then it is a question of services there. But here it is of notices. You see, service of notices. Service of order is different than
quite
notice.
true, my lord.
In fact, the order could not also be in the portal. Can the order be in the portal?
But in fact, my lord,
The young Dr.
my lord,
Todi,
so far the rights of the person.
can the order be also in the portal? There's a difference out there. You see, 169 says service of notice in the portal. What do you say about the order?
169-2. 169-2.
Every decision order so and so shall be deemed to be served on the day on which it is tendered or published, or copy thereof is affixed and a one. What do you do at the time of registration? You have to give your email address also, na? Everybody.
Phone number.
And you did not get it in your email. By any one of the following methods. Chalo. Hearing complete judgment
In item
results.
21, I want to place the notice.
Huh?
Item 21.
Ah.
Everything is mentioned here as per the format of the notice.
Item 21, what is the repetition number?
It is 4502.
4500, yes.
Page 26.
Oh, his case is bad.
Here lordship for date was also fixed.
His case is really bad.
51 notice was
Let
issued.
us see what it is. Registration,
Page
date of
26 is the notice.
liability. Ah. Everything is mentioned.
Yes, right.
And here, did you supply the reply?
Lordship for
No,
you stated
not-
that the your reply dated
Reply has not been
71.
Did you file any reply?
No, man. I have not filed.
Follow it is mentioned with reference to your reply, but I have not found it.
Mr. Kyle, why he has done this, I'll tell you why the reply has been mentioned. You see, 22, Rule 22 categorically says that you are to pass the order within 30 days.
Yes.
The reply is to be filed within 7 days. You see? 7 days, as per Rule 22 itself.
Yeah.
21. You have to file your reply within 7 days. At 7 days from 5 would be when?
Is,
12.
within 17 months.
In fact, how is it that he has been doing business from 2021?
His registration.
Are you not doing any business?
Some other business are doing.
So not here. Now, why do you want it to be?
Now, my
revoked?
lord, I wanted to, I intended to do. Because this is the only business. But due to after my lord,
Did you file your return?
but filed.
Huh?
28 minutes. Page 28 minutes. In my lord, 21 minutes.
Page
21.
29.
28. Page 20. File on my lord, 29/7/2024.
So,
Till the
till
date,
the date of cancellation, you have filed your returns.
after that, my lord, just block my lord. I have not filed. I am trying, my lord. But I am trying to, my lord, submit it.
Chalo. Hearing complete judgment. review.
Lordship permit me, my lord, can I submit your lordship judgment, my lord? For any reference, your lordship judgments are there, my lord.
Which one?
Two judgments on the issue, my lord. Case of registration, if your lordship, my lord.
Lordship, the DRC notice case number is 3912 of 2473.
Which one?
The under section 73, Lordship has directed that
DRC
along with DRC one, Lordship, along with the show cause, there has to be the case number is 3912 of 24.
But Dr. Toti, with due respect to my brother, in this judgment passed in WPC number 6366/2023, which you are referring to, more particularly kindly see paragraph 8, not my judgment, passed by my brother in the last judgment which you are referring to, in WPC number 6366/2023.
6366, my lord. 6366.
6333.
Yes, ma'am.
And you'll see paragraph 8.
In fact, my lord, I have just played because lordship, my lord. To lordship.
No. Yeah. How can I remand it to that officer concerned? Because he has submitted his return. It can't be permissible because he has no authority to revoke.
Correct, my lord.
The revocation can only be done either by us, we can do it,
Correct, my lord.
or can be done by that authority who can
Correct.
revoke.
Correct, my lord.
But if we allow it, are we not conferring a jurisdiction on an authority who doesn't have?
Again, my lord, again, the self problem.
No, he doesn't have the
Yes,
jurisdiction.
yes, my lord.
So therefore, the question of him exercising, I
Lord,
don't
perhaps, my
think
lord,
this
lord,
may
my
be in accordance with the provisions, paragraph 8. Because here the direction kindly see, having regard to the GST and has cancelled under here for the reason that the petitioner did not submit the return for the last 6 months and more so, and the provisions contained in the provision dated this court is of the considered view that in the event the petitioner approaches the officer duly empowered by furnishing all the pending returns and make full payment of the debts dues along with interest so and so. The officer duly has the authority and jurisdiction to drop the proceedings and pass an order in the prescribed form.
Lord, I stand corrected, my lord. In fact, my lord, what happened? Lordship has rightly said, my lord, in fact. But determination has to be first, my lord. Direction should be there to determine. Of his own, my lord, they cannot submit return. Quite true, my lord. What Lordship has observed a few minutes back, my lord. That is, my lord, perhaps, my lord, this will not help. In fact, for my lord, complete solution will not be from.
No, as per the scheme which look, he has to submit his return. There's no quarrel in view of the third proviso. He has to submit his return up till the date of cancellation, along with interest, whatever may be. And in these cases, it has been shown as 0. But the second is, he has to approach the authority who can revoke. He cannot approach an authority along with an application for revocation. He cannot approach the authority who cancelled. I think the cancellation and revocation are two different authorities.
Yes, my lord, it has to be direction, my lord. Oblige, my lord. So, Lordship, my lord, can note it, my lord. Much already.
And Mr. Counsel, kindly give your names against which writ petitions, huh? Hearing-
Admission item 1 to 3.
In this case, Lordship, I am praying for another 10 this time.
Why? After
So,
passing of
Lordship,
the last order on
lacking on
1811.
our part, Lordship, the mail goes only yesterday evening. Because of some
The H.
technical.
Sharma appearing. And Mr. Sharma, you appear.
Lordship,
next time.
Lordship, in this case,
You are
Lordship,
not
I will-
appearing in this matter. Earlier, you have been appearing in this
Lordship.
matter.
Lordship, I will.
That is the problem which arises. Another new counsel comes and appears. Have to again explain head and tail,
Lordship, I will appear.
isn't it? Mr. H. Sharma appearing on behalf of the petitioner submits that the instructions so sought for by the order dated 18/11/2024 was only placed before the authorities yesterday, and as such, some time is required. First, to place this matter again on 18/12/2020.
Lordship, may I pray my name may be shown. Lord. In that case, it is easier on.
It shall show the name of Mr. H. Sharma as the counsel who is representing the district administration.
Much of it.
Item 4.
See, it didn't say. Yes, Mr. Mazinda, what is this case?
Is that matter where for constructing a model degree college? Relinquishment. Relinquishment.
Oh,
Favor of
yes.
the government.
Then what happened?
Pursuant to the last deliberation, my lord, since relinquishment in this case, otherwise relinquishment would require registration if it is immovable property. But in this case, since the relinquishment was in favor of the government, perhaps because there is no change in title, registration may not be necessary, my lord. But
Why?
But the land revenue regulation, my lord, although it provides for the power is there, power of relinquishment is there, but the manner is not prescribed. Now, how the land can be relinquished. So, this matter, my lord, I pray for 1 week's time, my lord, I'll some.
This is some persons who are there whose lands were taken out on the basis of some relinquishment.
Yes. Fact,
He has said that how can there be a relinquishment without a registration? So therefore, that is a null and void. This is your case.
my lord,
And the other point is, my lord, few of the petitioners have not even relinquished their land. Out of 24, 14, as per the affidavit in opposition, they have relinquished their portion of the land, but the remaining 10 petitioners, they have not relinquished.
So there are some development which I indicated in the last time because of positive of time will lordship could not take up. My lord, in respect of, this is in respect of Dhubri. In South Salman also similar problem came. And in fact, throughout the district in Assam, such model degree college has been constructed and nobody has objected. Now, in respect of South Salman also, there was
When
some
did this incident happen?
started from
19.
possibly in 2019, 2017, my lord. And what has happened in respect of South Salman also similar problem came and they filed a petition. The petition was taken up by one Justice Chaudhary.
I placed the
Manish
judgment
Chaudhary.
on the other, I placed the judgment. Yeah.
So that there the petition was dismissed on the ground that disputed questions of fact that there this court in exercise the power under Article 226 will not go into all this. Then they preferred a writ appeal. Now during the pendency of the writ appeal, my lord, it was indicated initially by the appellant petitioners themselves that the authority is considering give them an alternative land.
Huh?
Alternative land. Not only that, my lord, earlier in one batch of petition before on Justice Suman Shyam, in the writ proceedings before the single judge itself, my lord, order was passed, interim order was passed that you see if you can provide them any alternative land. Now, in the writ appeal, my
By
lord,
interim order, it couldn't have been. It was, must,
No, I-
must have been said that if the government, it shall be within the wisdom of the government to
Ah,
do so, something
my
like that.
lord, that ultimately writ petition was dismissed by a different court, my lord. And in the writ appellate court, when they submitted that, and we also had instruction, actually, in fact, they are actually being given alternative land. One set of land was given, plot of land was given, but they say it is not conducive to their requirements. So negotiations are going on. That way, my lord, an order has been passed.
But Mr. Majumdar,
I know.
what what was my opinion that day?
My lord.
His case was the case of relinquishment cannot be done without a registered document.
Right.
I said something else. I said that he didn't have a case because of the fact that relinquishment, not a case of relinquishment out there. And because the government, yes, the government
My
was the owner, is the owner of the land.
Yes, but that is, I also submitted your lordship also.
I said
informed.
the government was the owner of the land.
Yes,
and as
ownership
such,
remains.
huh?
Ownership remains with the government.
And they have been given a lease.
Lease. So the
And when they are given a lease, the
My lord.
question of relinquishment does not appear
My
because
lord, that
if the moment they say that I don't want it,
Yes.
it reverts back to the
Revert back
government.
to the government, because ownership, even otherwise, even in the case of a lease, remains with the government. So that was the deliberation, but anyway, my lord,
That
in the,
flows from
My lord, in
Article
the-
296. That flows from Article 296. My lord.
My
Land
lord-
is relinquished, it becomes bona vacantia and escheats on the.
but if your lordship takes up the matter for
Doctor,
disposal,
This
Doctor
point was
see,
never raised in the other petitions, my lord, that the point of registration, it was not raised in the other petitions referred to my learned senior friend.
in those cases in respect of South Salmara, my lord, this was the last order passed by the Divine Bench. Not common. Whether, my lord, in respect of this college also, similar stand is there or not, I'll have to take instruction. It's second for 9 years. Who soon? Have you can? That is the position in respect of the South Sangha. In fact, my lord, in this
No,
state,
these
all
are different things. Now, the question is, you have admitted that some have not relinquished. If
documents show
some
that,
have not relinquished, then how do you take care of it?
madam, if everybody has not,
How are these judgments relevant?
I'm not, this judgment has got nothing to do with the merit of
Let
the
us
case,
go on the admitted position
my lord.
that you have 10 of the persons have not relinquished. That is your admitted position.
It appears, my lord, because everybody, according to my learned friend, has not signed. For that also, I'll have to take instruction, because if there is any other document, because the affidavit which has been filed says that everybody has consented.
Does not say everybody, my lord. I'll read the
No.
document. That can be tallied from the relinquishment deeds itself, my lord, who have signed it, my lord. I have tallied, my lord, out of 24, 14 has purportedly, my lord, put their thumb impression, my lord. 10 have not signed the document.
So 10 have not, if they have not done it, then the question will be, why not an acquisition? Anyways. Mr. P. Mohanto thinks that I don't like 300A.
No, my lord, you would like to, you want some time procedure.
List the matter at the request of the learned counsel for the petitioner, matter be listed in the month of January. Hello, we call the Deputy Commissioner. This court, by an order dated 21/11/2024, directed the respondent number 2 and 3 to produce the deed of sale which was submitted by the petitioner before the respondent number 3 for registration. Neither any counsel appearing on the counsels appearing on behalf of the respondent's district administration on behalf of the respondent numbers 1, 2, and 3 are not present. Additionally, the said deed of sale has also not been produced. Accordingly, list this matter again on 16th of December 2024, on which date the senior sub-registrar Kamrup at Amingaon shall be present in the court along with the deed of sale which was presented by the petitioner before him for registration at 10:30 a.m.
Hearing item 7.
Madam, make the judge. I beg to make a prayer, madam.
Yes.
To agenda matter for a week, madam. This morning, I received the inquiry report from the police commissioner. I will submit it through an affidavit, madam. That is a 1 week time. madam.
You want to file an affidavit?
Yes. Although earlier affidavit filed, madam, inquiry was conducted by the police commissioner. That has been with me. That has been furnished in the morning. Along with the inquiry report, madam, I will file an affidavit.
You filed a consumer proceedings.
Yes.
What has happened?
While proceeding was on, my lord, the check which was called for, to proving that there's a deficient service for putting the signature by third party. That check was called for, but they could not produce it, police.
So,
So thereafter, my lord, I went to the state commission to find out the revision for calling the record. The state commission directed the consumer court to call the CGM record. When they couldn't produce the check in the court, my consumer court for 6 or 7 times. Then I have to appear before your lordship under 226. And your lordship was pleased to pass the order, my lord, for the constitutional inquiry in the, through the district judge, my lord. That inquiry was submitted and they said that check was missing while building, shifting of the police station.
Sir, that is not conclusive finding. That is why, my lord, an
So
affidavit.
judicial finding, my lord, by the commission, my lord, by this court, my lord.
when was the finding given report?
That is your
7/6/2017.
lordship, see the
Yes.
order dated of 24/4/17.
Where is the report?
Report is, my lord, dated 7/6/2017, my lord, is given in extra page, my lord, by the district judge, Kamrup.
The report is not here. Where? Oh, yeah. I've got a report. The original report. Huh? You go to some? Report two. Report. How to report? Thank you. Now, where's the report?
Report by the, I have a copy.
In fact, my lord,
The report of the session,
eh,
district and session judges, yeah, I have annexed. It's only record I have.
recorded some statement. Okay.
No, record of the district and session judge.
So your case is this report which was given, the check being lost, you could not
Get the compensation from the consumer forum because that for deficiency. of
compensation from whom?
service From the Bank of Baroda, because for deficiency of service, because my signature was forced and taken away the money from my account.
How can you claim compensation from the Bank of Baroda?
Deficiency of service because my signature has been copied and money was withdrawn by the third person in connivance with the bank officials. That comes under the purview of the consumer forum, my lord, for deficiency of service.
So you mean to say that the signature which was appearing in the check was not,
Yes.
did not match with the records available with the bank.
And this
And
is
as such, the bank could not have permitted this thing.
because that signature has been proved by the forensic laboratory. That signature is false. Because it is the duty of the bank to verify the signature or give a call to the party whether he has produced the check or not. The forensic report says the signature doesn't tally with mine. But when the record.
Then isn't it the case you had the certified copy of the check?
Certified photocopy mine.
Understood. So obviously, it has to be a photo certified copy.
Photocopy-
But you had a photo certified
photocopy,
copy.
But photocopy does not serve the purpose, my lord, because the signature has to be verified.
No. Signature has already been verified by the forensic. So the report is already there.
What is there, my lord?
No, so the report on the basis of the check being a fraudulent check issued by somebody is already there, that this is not your signature. So if the appreciation of facts were not taken into consideration by the consumer forum in the proper manner, they may have lost the check. That's a different aspect. That is another aspect of the matter. But wouldn't it be a case of filing an appeal before the authority, before the higher forum?
My lord, this, I have put the state commission, I have gone there. State commission will remand the matter back again
To,
to go for the evidence of the check.
on the basis of?
The report by the police that they don't have the check.
No, understood. But if the state commission have stated that you have to have the original check only.
Prove the case.
So as of now, the matter is pending before the state district.
No, district. District two.
So district for consumer forum, it is pending.
Yes.
Now you have not been able to prove it
Yes.
because of that check. Now, where is the state consumer forum's direction that you have to produce the original check?
No, that, we have filed the petition before the commissioner to lead the evidence, which was earlier closed by the state district commission. They said nothing doing, we are going to close your petition because the check was not produced yet. So we went to the state commission. The state commission directed the district forum, no, you call for the records and examine the matter.
Okay, now the district consumer forum has called for the records, have not got that check. It is lost. From the report, it is clear that it is lost. So under such circumstances, why are you can't be permitted to give secondary evidence there?
No, the secondary evidence file, then I have to again go for the.
No, the fact that it is lost, the fact that it has also been mentioned in the report given by the district, the district judge that it is lost, isn't that an ample proof of giving secondary evidence?
That is there, my lord, but the question would be, my lord, again, the secondary evidence, we have to call the other person also to prove it. The bank.
No,
will give an
you have
objection.
to, no, the fact, the bank will give an objection, that is a different thing. But the fact that this check is lost by the authorities concerned is a fact which is there, which is admissible on the basis of this report of the district judge, which you have sought for, and you have got that report that it is lost. So therefore, in view of earlier section 65,
Evidence.
wouldn't it come within the ambit of a secondary evidence?
It is there, my lord, but my lord, when it is original, when I go for the secondary evidence, naturally the bank will raise a lot.
Because you see, the check as of now is only for the purpose of proving that case. But that is not a check which is otherwise a negotiable instrument now, because it has already been negotiated.
Yes.
So under such, what case why should this court further entertain
my-
this type of litigation?
My lord, in this case, my lord, I submit one thing. my lord. When there is a loss for the check from the police custody, under 226, my lord, it can be compensated, my lord. Because of the effect.
Understood, the compensation will only arise if there is a finding to that effect that you cannot prove it. But can it be said that you cannot prove it on the basis of the certified copy of the check along with the forensic report?
Your
To
lord-
be a constitutional thought, can we extend this constitutional thought to that extent?
Up to your lordship, if your lordship direct the to consider as secondary evidence, we'll produce it. But the prosecuted will, my lord, this petition will suffer again because the bank will go to the higher court and they
The
will-
bank will go to the High Court, and otherwise, if it is rejected, you go to the High Court. But this is how it is. Just for example, tomorrow a sale deed is lost in the custody of the registrar, sub-registrar. The sub-registrar liable to pay for that. The question is, if you can still prove it on the basis of your secondary evidence, a certified copy, you can very well prove it that you see I would have understood that with the check, there was no forensic report. And as such, now you cannot go into the question of a forensic report because without the original check, you cannot have the forensic report. Then I would have understood. But you have a check which has the forensic report. Therefore, you can very well prove it. Anyways, Mr. B. Goswami is seeking time. But I think no case.
My lord, based on the 226 of the Supreme Court three-bench judgment, my lord. I relied on the Supreme Court judgment of the three-bench judgment, where says if the thing is stolen, missing from the police custody, police is liable to compensate.
For what?
For the loss of the, my lord.
Absolutely. There's no quarrel with that. If a
So it's
negotiation, just for example, gold, money, your money, which is there, which was seized, is lost. The police is liable to compensate. A check, which is negotiable, a bank guarantee, which is negotiable, can be. But a check or bank guarantee, which is not negotiable now, there's no loss because it has already been used. You may have a case of compensation later on that because of this, you have not got anything because of this. But the fact that now, for example, you have the original check. Let us admit that you have the original check. What are you going to do with that? Tell me.
No.
No. Tell me. Let us have it. For example, you have the original check. What are you going to do?
It will be proved in that court, my lord.
No, what it will be proved? What it will prove?
It will prove that there was a deficiency service on their part or not on.
No. When you bring the original check, you have to go for asking for a forensic.
Already done.
Forensic evidence is already there. You have the check. It is not that you don't have a check. You have a certified copy of still the check, which is a secondary evidence. So which can be very well admitted, taking into account that there is already there. What remains?
Whether lordship has granted me time for the filing the affidavit.
Huh?
Whether lordship has granted me time for the purpose of filing.
Why you are filing affidavit?
Because inquiry report is there. That is why.
What is wrong with the inquiry? But it is true. This is lost.
No, in fact, my lord, the search sheet, the clear case of the police is search sheet submitted on, my lord, 4/6/2006. On that day, it is the clear case of the police, my lord, along with the search sheet, the check, and the forensic report was submitted, my lord. And petitioner obtained certified copy of the check and forensic on 17/9/2007. And this is not the report of the district judgment. Only some orders of the, my lord, the CGM, my lord, that has been forwarded by the district judge. This is not conducted by the, that is why, my lord, since police commissioner has conducted an inquiry, my lord, to come to a conclusion, my lord, my humble prayer is to grant only.
No,
three
your
notices.
case is, you are saying
Yes,
that how will the petitioner get a
Yes,
certified copy of
absolutely.
the forensic report
My-
along with the check?
Yes.
Because when a check as well as the check is seized, it is being sent on the basis of an order being passed by the magistrate that it is required to be sent to the forensic. On the basis of that, a forensic report will be given along with the check, which will be returned to the court, not to the police. So it cannot be with the police.
Yes, that is,
Isn't that the simple
Yes.
case?
that is the simple.
But yeah, my
And
lord,
petitioner obtained it, my lord, on 17/9/2007.
my lord, when the charge sheet was filed, my lord, at that time we applied for the certified, photo certified copy. It was given, then it was sent to the forensic laboratory. Because it was never in the Malkhana.
Are
As
you
per the
saying that the
report.
charge sheet was submitted after forensic,
But yes,
before forensic?
no, before forensic,
Yes.
they first submitted the charge sheet. We applied for the report of the
No,
photocopy.
it can't be.
My
A
lord,
charge
then-
sheet
then-
cannot
then
be
it was
on the
missing, my
basis,
lord.
unless there is an opinion of the forensic, how is
Yes.
it possible?
And he,
Then it was
he
missing.
submitted his application on 18/8/2007, my lord, for the purpose of obtaining the certified copy of the forensic report and the check, my lord.
When did you obtain the certified copy?
17/9/2007. The petitioner himself has admitted and it annexed.
Yes, yes.
One, two. I mean,
17/9/2007.
my lord, yes, 17/9/2007, and search sheet was submitted on 4/6/2006.
7/8/2007.
Yes,
The accused aforesaid has filed a petition under section 104 allowing them to be represented by the council through so-and-so stating that it is inconvenient for them to come. Other accused so-and-so, fixing so-and-so, the name of the bailer. Accused so-and-so. What is the date of the forensic report?
6/12/2005. 6/12/2005. Please find here the progress of the opinion of censor, document stamped and marked as censor. His 29 of his report.
A charge sheet given on
My lord, 20, not for 26, 23/3/2006.
2006. So that is therefore the opinion. Now this opinion is given to the Deputy Superintendent of Police Dispute Division. And the opinion was given on 6/12/2005.
28/11/05. Opinion was given.
Where do I get the charge sheet with?
Charge sheet is not in the.
Now in this charge sheet, which was submitted on 23/3/2006,
Yes.
it mentioned about inclusion of MR 200/0005 and MR 201. So if it is included and it has been received, how can it be lost?
Possibly, my lord. From the custody of the prosecution inspector.
Hmm?
Maybe, my lord, from the custody of the prosecution inspector there.
It should be from them only. It can't be from there because it is included. And here these people have signed it now. The judge has to sign it. Two Caesar list and one effective for the favor of initiating trial against the accused. Two Caesar lists and one FSL report enclosed. And from where did you get the certified copy?
From the CGM, man. From the CGM itself.
So if you have got it can't be from them.
My lord. Your lordship will come to the annexure 6 page 27, my lord.
Of what?
Of my petition, my lord.
What does it say?
This is a certified copy of the photo of the check, my lord.
He must have given you from a photo certified copy, another photo certificate. Annexure 7.
Annexure 6.
Annexure?
Annexure 6 page 27.
Page 20?
27.
Yes.
And this is a check given to me, certified copy.
By
I
the
have
office-
applied for 18/8/2007, my lord. 27/5/2000, it was ready, it was given me. Now your lordship will come to the next page, my lord, 28. The opinion, my lord. Because in the check, my lord, they have quoted, your lordship. Some mark was given in the check after that, after the FSL report. That will, your lordship will find page 28 and 29. That is, before submitting of the FSL report, this certified copy was obtained.
Because in the check, my original check, there will be a mark like Q1, Q8,
Hmm.
Q S1, S2 in two sheets. That is not there. So it is cannot be said that after charge sheet I have.
In fact, this certified copy which you are getting is not the original from the original check.
This was given by the court, my lord.
They may have given you.
Actually,
Mr. Vatsalji, they may have given you. They have given you this. I'll show you what they have given you. I'll show you what they have done.
account number is same, everything is same, my lord.
See this. They have given you this exactly. Mark X. This is the document they have given you. See exactly the same. 526. See? Because without marking which one is Q1 and Q2,
Okay.
how can there be an opinion? This must have been taken prior to that and taken a photocopy.
I have no. But it is after.
I think when you are having that lost thing, let it be as a lost and then prove it as per the forensic. Further digging out here may have more disastrous consequences upon them.
My lord, maybe, my lord, because that other accused, they have got acquittal on the basis of this because of non-production of the check. Otherwise, if the check was there, they would have been acquitted. Now, I am the citizen, my lord, I have to suffer. For whose fault, my lord? That is your lordship will see. I am a doctor by profession, my lord, 4,20,000.
And this is a self-drawn check.
This is self-drawn check. And the person who has done it in connivance with the bank, my lord. That is what charge sheet, my lord. That is.
No, Mr.
That is.
Bhattacharjee, I understand you. But if I say that this is the certified copy of this check, and the further opinion is already there, then in that case, if the original is not there, the district consider as per the secondary evidence.
But secondary evidence has to be considered, my lord. There must be a mark.
Mr. Bhattacharjee,
I
you are
understand
not
what-
understanding. If we go further deep into that, your matter will get.
But my lord,
Let them not put that question out there.
my lord, the question would be, my lord, in the check, my lord, when the document was stamped and marked as Q1, Q8, where it will be proved, my lord, when the original is not there, my lord. That has to be proved at least, my lord. Because the bank has the power to go to the National Commission on this appeal, but we cannot, my lord. But the question here is, my lord, where is the check? If it is missing from the police custody, if the fact is that, my lord,
So therefore, the question is, this cannot be the certified copy of the original check.
then your lordship, that I have no problem. CGM will say because they have given this copy.
They may have given,
Then,
but this can't be that.
then your lordship will. consider
I
that
understand
it is
your
found out.
question, I understand, because you have categorically stated. Your basic question is, how do you prove this? Along with that particular opinion.
My lord,
Because the opinion says about Q1 and Q2. And there is no marking of Q1 and
in
Q2.
in the check. That means original must be somewhere here, my lord. Original must be somewhere here in the court, my lord. Because without the original check, it will not be possible, my lord. The Q1 and Q2 will be marked because they will go to the appeal and I'll be at loss, my lord. But the question is that the person who has entered into this matter, the SI, he himself admitted that while shifting of the police station, check was missed.
Now, if I ask for, I think the district judge's report, it doesn't seem to be proper.
Then you go, your lordship will go for a fresh opinion, my lord, to find out whether the original check is.
Because the district judge ought to have inquired as to how a certified copy it was
Yes,
given,
yes, my lord. That
which is not there.
there, not sure to direct that CGM to take the instruction, how he has given the certified copy of this check. Check number is telling me.
So from whom are you asking the money now?
Actually,
Compensation.
I have filed against the Bank of Baroda. Now, since
Now you are asking the compensation from whom?
state man, police for his negligence.
State.
Yes.
Because if your lordship.
And if the mistake is of that,
Yes, of the.
Malkhana also is the state.
Malkhana, no. Malkhana is under the custody of the PI. State.
So it will be then the judicial department.
If your lordship, I'll just
If
place
that
this
is so.
order now.
If that is so,
I will place, one judgment allows Supreme Court, your lordship will go. Please.
I hope. Heard Mr. K. Bhattacharjee, the learned counsel appearing on behalf of the petitioner, as well as Mr. B. Goswami, the learned commissioner advocate general, Wassam. From a perusal of the materials and report, it is seen that this court had called for a report from the district and session judge Kamrup as regards the missing of the check bearing number 757396 drawn on Bank of Baroda purportedly by the petitioner. It is further seen from the charge sheet which was submitted on, when is the charge sheet submitted? 25/6 or what is that? Charge sheet submitted on
custom. Submitted on, my lord, 23/3/2006.
2003, 23/3/2006.
That is charge sheet dated, submitted along with the document to the court of the CGM on 4/6/2006.
On 4/6/2006. That along with the charge sheet, what were enclosed with, therewith, were 2 Caesar lists and 1 FSL report. Be it as it may, the petitioner herein was provided certified copy of the check in question
As well as the FSL report.
on 17/9/2017,
2007.
along with the opinion dated 28/11/2005. Mr. B. Goswami, the learned advocate general, submitted that in the report so submitted by the district and session judge Kamrup, dated 7/6/2017, is to be believed. Then how? The petitioner was provided with a certified copy of the check as well as
FSL report.
of the check in question on 17/9/2007, much after the submission of the charge sheet on a date to this.
4/6/2006.
This court have also duly perused the report of dated 7/6/2017 of the District and Session Judge Kamrup, which however does not appear to be satisfactory in as much as it does not, in as much as it, nothing is seen as regards the inquiry so conducted as was directed by this court. The learned district and session judge merely forwarded the reports of the prosecuting inspector as well as the learned chief judicial magistrate Kamrup Metro However, in the said report, there is no mention as to how the certified copy was issued to the petitioner of the check on 17/9/2007. This court have also perused the opinion dated 28/11/2005 issued by the senior scientific officer, Forensic Science Laboratory, Assam, wherein there is a mention from scientific Forensic Science Laboratory, Assam, and it is seen therefrom that the check in question was marked the check which was placed for examination was marked with Q initials Q1, Q2, and Q1, Q1, Q2, Q3, Q4, and Q5. And a mark from Q1 to Q8. However, from the certified copy of the check which was placed before, which was provided to the petitioner, it is seen that there is no marking in the said check. Therefore, in the opinion of this court, it is also seen that the opinion dated 28/11/2005 was also addressed to the Deputy Superintendent of Police, Dispute Division. Therefore, it is seen that while making the inquiry and submitting the report, the learned district judge on 7/6/2017 did not address to those aspects. Accordingly, this court is of the opinion that while retaining the said inquiry report dated 7/6/2017 in the records, the interest of justice would be met if the district and session judge, Kamrup Metro, is directed to further make another inquiry as regards the missing of the said check bearing number 757396 drawn on the Bank of Baroda, which was the subject matter of the opinion, which was the basis on which the opinion was rendered on 28/11/2005. List this matter again on 22nd of January 2024. In the meantime, 22nd,
Second, 25.
25. No, 23rd of January 2020. In the meantime, the registry is directed to forthwith communicate the instant order to the district and session judge, Kamrup Metro, to make an inquiry and submit a report on or before. Now, let us have it in the month of February, on 5th of February, 4th of February, 6th of February, 6th of February.
6, 7
Submit a
February.
report.
6, 7 February, I have some personal.
Let
Number
them
8.
submit a report, Mr.
Yes,
Babusamy.
yes,
Why,
yes.
let us first get the report.
Everything might not be simplified.
In the meantime, you want to file your affidavit, file it. 6th of February 2024 or 11th of February 2024. And the report be submitted before the registry of this court by 7th of February by the district and session judge, Kamrup Metro. The records of GR case number 5023/2005, which have been attached along with the instant proceedings, be also furnished to the registry shall also furnish the records of GR case number 5023/05 to the district and session judge, Kamrup Metro, for the which would enable him or her, him to arrive at a proper to make a proper report, to make the proper inquiry and submit the reports. List accordingly. Who are you?
Ben.
Did you say anything? Your presence, everybody's presence will be put in golden letters on top. Naam sab likhi diyo. You have to put it in the slip.
Lordship, I will simply, item number 5, Lordship, I will next in some order.
Oh, we have asked the sub-register to be present in the court.
Pretty much that record has been given to me, Lordship.
You have the register. Show me.
Only mother that
We'll take it up at 2. And ask the council, request the council, not ask, request the council to be present.
otherwise, Lordship, can it be fixed in tomorrow, Lordship?
No, today, either today or we see him on 17th or 18th. Presence of the senior.
Already my that record.
Okay, 2, requesting. Yes, Mr. Chaudhary.
Yes, my lord. My lord, these petitioners, they're all dentists, my lord. Now, they were recruited as 3F, my lord. In between 2011 and 15. Lord, we are praying for a consideration for our regulation.
Listed before any other bench.
Recently, my lord, the one judgment has been delivered. I'll pray for a similar direction.
What delivered? By another court.
Yes.
I can put an order that matters, similar matters have been taken place by a coordinate bench listed before them. Sorry, I don't like to request the government. Either direct, first, how do I direct a request that say that they will submit and consider regularization? Regularization absolutely,
In terms of Uma Devi Millard, one time.
but regularization is absolutely within the realm of them.
It's not that our entry is illegal. There was an advertisement, person to advertisement we were recruited. But we were recruited as 3M. All these aspects are considered in the judgment which has been recently delivered, madam, where the CDPOs have been directed to be, to frame a scheme.
How can it be possible? It is absolutely within the realm of the government.
Supreme Court in that Jammu and Kashmir case said, Lordships cannot direct regularization, but Lordships can direct regularization. Sorry, framing of a scheme. In
How
fact,
can that, isn't that the same? If the Jammu and Kashmir case is looked into, he said that there's a difference from saying that the court cannot direct regularization as Uma Devi has said. It's okay. But it does not preclude the government to frame a scheme.
Yes.
This is the wording used,
but
not
in
the court
having-
for directing them to frame a
with
scheme.
regard to that, my lord, if in an appropriate case where otherwise, my lord, the conditions are fulfilled, in that case, if the government does not come forward, then my lord, citizens will go to where, my lord?
Work like that? No, the problem which arises, Mr. Chaudhary, is one has to keep it separate. Otherwise, there will be, not today, every time there will be a problem. I pass an order like this, it will follow.
And
It becomes a very difficult precedent.
In this
And in fact,
judgment,
my lord, department had already in the year 2018 has issued an advertisement, my lord. And wherein, my lord, the petitioners, the PF appointed, they have been given some weightage, extra 20 marks in the interview, my lord.
Then,
But they have applied, but there is an interim order passed by this honorable court to keep 36 posts vacant for the petitioner. That's why, my lord, it is not concluded. The process has not been concluded due to the interim
how
order.
can there be an interim order?
My lord, in fact, what happened, my lord, while passing the interim order, my lord, the court, there was several directions that, my lord, endeavor will be there to dispose of the matter at an early date. But there was a COVID situation or something like that, my lord, and because of that, my lord, the matter is lying pending, my lord. Otherwise, the advertisement has been issued in the year 2018, my lord. For filling up of 7.
But Mr. Chaudhary, have your people applied?
Yes, my lord, they have applied.
If they have applied, they have been given weightage, good.
And 20 marks, my lord. 20 marks they have been
It is
given.
out of 100.
Affidavit, my lord.
Out of 100.
Yes, my lord. 20%, 20%. Out of 100%, 20% they have been, they will be given weightage, my lord.
I think all have not applied. That's the instruction.
Has the application process closed?
Yes, my lord.
Huh?
Yes, my lord. That is.
I can only ask them one thing. Allowing all to apply.
Yes, my lord.
You are allowing? Mr. Bora?
Yes, my lord. That can be done, my lord.
That is the only.
That we'll pray for we'll pray for an order on merit. Actually.
No, if you are given 20%, then I think it is.
No, my lord, how can I compete with the fresh candidate, my lord? We were recruited in 2011.
What are you going to be? You are not going to be, you are not police to be running around.
A fresh candidate and.
They are getting 20% extra marks, my
You
lord,
are getting-
compared to the fresh candidates. my
No,
lord.
no, I think page 38. That's the advertisement, my lord. 20 marks really good question.
In our affidavit, we have said. so, my
In
lord.
advertisement, it is said, my lord.
Weightage will be given to
Ah.
the candidates who are already rendering services so and so under 3F and on contract basis under the government organization. Those who are given here. Now weightage has been given as 20%. How do you say?
My lord, in our affidavit,
You have stated that.
yes, my lord, affidavit filed on 11/6/2019, my lord, in para 9, we have specifically stated. Para 9, my lord.
Where is your affidavit?
But if it dated 11
That is saying no
2019.
affidavit.
Page 49.
Affidavit filed in opposition with. Para 9.
Paragraph 9, my lord.
Subject to a maximum, it would be has been requested to give weightage as per the formulation of 5 marks for each completed year of service under 3F, subject to a maximum of 20% marks of the total marks. However, as the matter of allotment is a confidential, hence the same has not been placed in the public domain.
Has not been stipulated in the advertisement. But
That is the only thing I can do to you. And he accepts. He says that he will allow all the petitions.
they will be allowed. The lordship may direct, but so far as I know, my lord, probably all of
You
them-
cannot only allow the petitioner, you have to allow all 3F.
No, these are the only three of them. There is
No. All 3F. Because there might be others who are not here.
Yes, my lord, yes, my lord.
Because otherwise, again, the problem will arise.
No, recruitment whole process was not stayed. Only 36 posts were directed not.
But then
to
also
fill.
nothing has happened, selection process.
No.
No, my lord. Due to the
Therefore,
interim order, is that-
Let all the 3F, because otherwise tomorrow,
Yes,
when a
my lord.
matter goes, somebody else will come up and move in the
I
division.
think all the more or less all are before a lordship.
Yes.
As a matter of abandoned.
Yes,
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 my lord.
that is a different
Your
aspect.
lordship may,
yes.
pass
I
a
think
direct
that would
circular.
be more helpful
Yes.
later on. Otherwise, later on, you may have a problem filing. An appeal would be filed saying that the department, and again you are stranded. Already 5 years have gone.
My lord, can I place the recent judgment of
Yeah.
our High Court? Please come to para 33, madam. Having considered the above facts and the law laid down by the Honorable Supreme Court, undoubtedly petitioners would not have indefeasible right to claim for regularization of their services as they have been appointed on contractual basis. However, there may not be an absolute bar for the executive or legislature to frame an appropriate scheme for a regularization scheme. In the present case, as noted above, although the post of CDPOs are to be filled up to APSC, due to exigencies involved with the relevant point of time, the appointment of the petitioners have been made by following a due process of selection, wherein other eligible interested candidates had also participated. In my view, respondent authorities may consider framing an appropriate regularization scheme as the executive or the legislature is competent to frame such a scheme. In view of the discussion made herein above, this court is of the considered opinion.
Regularization scheme means there is a requirement of either bringing new post.
No, my lord, we are already working against sanction post.
If it is against any post out there, then obviously.
Yes.
But the
we are-
question is, Mr. Chaudhary, how will this help?
No, all that we are
No,
seeing.
this is,
No, my lord,
tomorrow, can you file a contempt? Tell me, can you file a contempt against?
this scheme, yes.
No. Kindly see the language.
yes.
You cannot. In view of that, may consider.
Yes.
May consider. See? You may only say that they have not considered and file an affidavit.
This order will help our cause. Mr. I think if this order is similar here by law contractual.
Then obviously they may do so without touching on the advertisement. Let the advertisement go ahead.
Yes, my lord. Yes, my lord.
They may
Advertisement-
consider this. You may be considered for regulation, yeah, but without touching on the advertisement,
Yes, my lord.
then
No,
they.
my lord. No, the advertisement post will have to be taken note of, my lord.
Why?
At least. No, my lord, regarding the 30.
Are these posts advertised?
Yes,
No, my lord, because.
Yes, yes,
3F
my lord,
says,
what had
my
hap-
lord, TF is against a temporary post, my lord.
Yes,
And
it's a
in their
temporary post.
appointment, It is not said that, my lord, their appointment has.
My
been
lord,
made
if
against
you are
the section.
making a 3F appointment, then you are supposed to make regular selection within 4 months. Read the law. You're supposed to make regular recruitment in 4 months. A 2011 appointment you have done in 2018. Somesh Kumar Thapial's case, my lord, Supreme Court has said, what else these people will do, my lord? They're seeking employment.
When?
Uh,
When did the Supreme Court say?
In Ramesh Kumar Thapial's case, my lord,
Which year?
no, regarding the plight of these people, my
No,
lord.
no,
when
which
they-
year?
2110 SCC 116.
What does it say?
Yes, it says, my lord, that, what choice do this citizen have? That has been considered in this case, my lord.
Hmm.
Yes, I'll place in that judgment. One second.
It is there in paragraph 31.
Yes.
There
In
it
this
mentions the
case, my
appellants
lord,
were appointed
Ah.
after going through the process of selection, which indeed was an appointment on substantive basis, and since the appellants were not in equal bargaining position when in the employers
Yes.
with the offer of-
para 37.
When was the judgment delivered? Case of Pratap had of that help that you should need not be about it in the. Then kindly see next page, paragraph 31 down below. In the case of Pratap Panda, Kishore Panda, the Supreme Court said that these decisions should not be taken into account in view of Uma Devi.
No, my lord, Uma Devi is discussed. Next page, my lord.
Honorable sir, equally important.
Sorry, this Jammu and Kashmir case is discussed.
Narendra Modi had-
However, Uma Devi is not an authority for the proposition that executive or the legislature cannot.
You see, what the Uma Devi says, or if you see even the Jammu and Kashmir case,
Yes.
one thing is very interestingly say
It's para
that-
11 is quoted.
that you cannot make illegal appointments, means you cannot regularize illegal appointments.
this
What can you do
It's
is
an irregular appointment.
irregular appointments can be
My
regularized.
lord, what had happened? In this case, there was a regular advertisement, which they have not denied. They admit that they were appointed post advertisement. My lord. Only thing is, my lord, due to administrative exigency, they described it as a 3F. There was a regular advertisement, there was a regular selection, there was a regular interview.
Let me come back at 2. Think about it. I am not so favorable with this type of orders. So registration has not happened.
Only because of my lord that new. My lord that notification come.
Okay, order to change query. List this matter again on
Earlier,
let it be listed next week. You produce this, it is with you.
Okay.
List this matter again, Mr. J. Hendrick, the learned counsel, has produced the original copy of the original deed of sale, original
Deed of-
copy of the, no, original copy of the deed of sale which have been executed and have, and was presented for registration. Just list this matter, taking into account, and list this matter again on 4th of December 2024, on which date Mr. J. Hendricks shall again produce the said deed of said document. আগৰ সেই অৰ্ডাৰটো কাটাই দিব। Yes, where is Mr. Ken Chaudhary?
And my lord, may I point out one thing, my lord?
Hmm.
In paragraph 6 of my affidavit, we have stated, because immediately after that, my lord, we initiated the process for making the regular selection, but due to some circumstances, it could not be done. Paragraph 6, my lord, and I have stated, my lord.
The Bora, I am in your favor.
Yes, my lord, I understand, but otherwise also their contention there. my lord, they are-
Irrespective of everything, I am not going to pass an order to that effect for asking you to consider.
And our.
I don't have the
at
habit
this
of
stage,
considering.
our stress is that because, my lord, entire selection process has been in hold, my lord. And if your lordship peruses last order of the honorable court, there was direction for making endeavor to dispose of some matter. But due to COVID and other circumstances, it has gone delayed, my lord.
Let us see Ramesh appeal judge.
The judgment, my lord, yes.
So here the Supreme Court held that they have been substantially appointed.
In our case also, my lord, there were advertisements.
Oh, but your advertisement was under 3F.
Definitely. I'm not saying it's for, my lord, in the other case of the coordinate bench of this honorable, that was also an advertisement for contractual appointment. In fact, my lord, if your lordship would kindly have this one more judgment, 2018 8 SCC 238. These are all post Uma Devi, my lord. Para 7.
2017, that judgment.
Yes, Jammu
Look
and
at-
Kashmir.
You have that?
Yes, yes. State of Jammu and Kashmir versus my lord, the
District Bar Association of Bandipora.
Para 11, lordship, I can leave it. My lord, as long as the appointment was irregular, this Uma Devi has been understood by several judgments of the Supreme Court is of enabling nature.
Now, here it says, kindly see 11. The decision when Uma Devi first dealt with the right claimed by the temporary employees to be regularized in service on the basis of long continuance, legitimate expectation, employment under the state and the directive principles.
On
The
both
sec-
counts, it
The
was
second
rejected.
salient question which the Constitution bench was called upon to answer was whether the courts would be justified in issuing of directions for regularization based on such features such as equality and long spells of service. On both counts, the Constitution bench held that against the temporary employees. However, Uma Devi is not an authority for the proposition that the executive or the legislature cannot frame a scheme for regularization. Uma Devi does not denude the state or its instrumentalities for framing a scheme for regularization.
My lord,
Now-
in other words, my lord,
Yeah.
if I may say so, my lord, Uma Devi is a restraint on the power of the court. It
Yes.
is not a restraint on the power of the authority, executive. Now, therefore, my lord, in a given case where in spite of fulfilling para 53 of Uma Devi, if the executive does not do anything, then what the citizens do? Lordship is confronted with that issue. Here is a case, we otherwise fulfill para 53 of Uma Devi as well as Kesari's case. Now, still they are not doing
Let us
anything.
see, para 53 says in a different level. One
Yes.
aspect needs to be clarified. There may be cases where irregular appointments, not illegal appointments.
Yes,
As explained in so and so and referred to in para 15 above of a duly qualified person in duly sanctioned vacant post might have been made, and the employees have continued to work for 10 years or more,
Hmm.
but without the intervention of
Of
the
the
orders
court.
of the court or tribunals. The question of regularization of the services of such may have to be considered on merits in the light of the principles settled by this court in the
Yes.
cases above referred to and in the light of the judgment. In that context, the Union of India State and its instrumentalities should take steps to regularize as a one-time measure
exactly. my lord.
the services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under cover of orders of the courts or tribunals,
Yes.
and should further ensure that regular recruitments are undertaken to fill those vacant section posts that require to be filled up in case where temporary employees or daily wages are being held. The process must be set in motion within 6 months from this date. But this is a one time. Then,
They have not done, my lord.
no, then it was done. But did you, no,
My
but,
lord,
the-
what
what-
I'm trying, no, my lord,
but, Mr. Chaudhary, this was 2017.
18.
Judgment of Uma Devi is 2017.
7,
From when the judge, no, Uma Devi is earlier, 2006.
6.
So that was given for that 10 years, not for every time a 10 years come.
No, what I'm saying is, supposing after the judgment in Uma Devi, if there was an irregular appointment, then they should take measures for at least one time measure, which they have not taken.
Every time there might be many
No, I'm not
cases.
saying every time, this is the only occasion. After Uma Devi, this is the only occasion.
Health department has hundreds, not in
No, no.
thousands.
As far as doctors are concerned, and
Everywhere,
whether dental surgeons are concerned, this is the only case. There's no other case.
there is no end, Mr. Chaudhary. Every time it will come up. First of all, this was
my lord,
exercised under
Madhavi-
152,
Madhavi-
142.
My lord, Madhavi has been understood by benches of the Honorable Supreme Court in different ways. My lord, my humble understanding is there are three requirements. First, the appointment must be made to some sanctioned post. It must not be an illegal appointment. It must be an irregular appointment. And they must have worked for 10 years. It is in such a situation, then the person concerned, they acquire a right for consideration. Now, my lord, this 10 years has been diluted subsequently in Amarendra Mahapatra's case, where it says 10 years or so. So, my lord, in our case, we were appointed in 2011 onwards. Now we are in 2024 end. Now, my lord, they, instead of regularizing us, they have advertised the post. It is at that stage we came before this honorable court. This honorable court said, keep 36 posts vacant. That they did not went ahead with the other post, that's a different aspect. But this court protected our right. Now, my question is, my lord, a coordinate bench of this honorable court has taken a clear view, saying there is no bar on the part of the executive. Now, if executive sits tight, then what does the citizen do? That's the question. They will consider. If they don't consider, they let them give reasons. If they have to reject my case, they must say, then I do not. follow
That
the-
would be because you see the question of regularization is different from creation from filling up a substantive post. These are two different aspects. When you regularize something, somebody
That's why it is said, my lord, the appointment must be a sanctioned post. That is why, otherwise my post has to exist.
and more particularly here you have half of it. If you see paragraph 26 of this judgment, the principles which have to be formulated bearing in mind the proposition of above judgment. Regularization is not a source of recruitment, nor it is
Certainly, my lord.
intended to confer
In
permanency upon
Nagaraja's case in
appointments
79,
which have been made without following the due process envisaged under 14 and 16. Essentially, a scheme of regularization in order to be held to be valid must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigencies, which is 3F. In all such cases, it may be left open to the courts to lift the veil to inquire whether the scheme is aimed at achieving the above objective and is a. Now, first there has to be a scheme.
That's what, my lord. They are not framing the scheme. We are against that only.
Understood? They are not scared. They,
No, no,
if they
if they-
frame a
my lord-
scheme, they have to create a post.
The posts are there.
No, that post
That's
cannot
why
be
they've
used.
advertised the post.
There is no right to that post, Mr.
No,
Sodri.
My lord, kindly see, there's one more judgment, 2018. This is 2018 8 SCC 238 para 7. এখন দিও না। দেখি তো, যখন হেরাই যাবে। এখন দিও। Now, my lord, kindly see this 2015-18 SCC, how Uma Devi was understood by the Supreme Court. Ekhon diok na.
This is which
Para
judgment?
11.
Which judgment?
My lord, this is Amarkanti Rai. Kindly have para 11, my lord. At page 113. Sorry. Please come to para 11. Elaborating upon the principles laid down in Uma Devi's case and explaining the difference between irregular and illegal appointments in state of Karnataka versus ML Keshari. This court held as under. It is evident from the above that there is an exception to the general principle against regularization enunciated in Uma Devi if the following conditions are fulfilled. The employee concerned should have worked for 10 years or more in duly sanctioned posts without the benefit or protection of interim order of any court or tribunal. In other words, the state government or its instrumentals should have employed employee and continuity in service voluntarily and continuously for more than 10 years. The appointment of such employees should not be illegal, even if irregular. Where appointments are not made or continued against sanctioned posts, or where the persons appointed do not possess the prescribed minimum qualification, the appointment will be considered to be legal. But where the person employed possessed the prescribed qualification and was working against the sanctioned post, but had been selected without undergoing process of open competition selection, such appointments are considered to be regular. So if these two conditions are fulfilled, my lord, then we fall.
No, Keshri's judgments specifically say that
Ah.
yes, the cutoff date is 10/4/2006.
Yes.
If the state concerned takes into consideration some of the persons and gives them the benefit of these 10 years and does not give the benefit to the others of this 10 years, then those who have been deprived can very well get the benefit under 53.
My lord, my humble understanding, subject to what your lordships may say, my lord, it's true. As has been said in the Jammu and Kashmir's case, normally court will not issue any direction. That means court will not say regularize. Court can always say, if the conditions laid down in Uma Devi is fulfilled, then the court can consider whether I am entitled to a direction for consideration. Not direction, a consideration. Now, issue is, my lord, why in Uma Devi it was said? It was said because the courts were issuing directions. 226 courts were issuing directions for regularization.
Operation Blackboard.
So therefore, my lord, not only in this part of the country, everywhere, my lord, whole country. So therefore, the Honorable Supreme Court said that a distinction was carved out between an illegal and irregular appointment, and an exception was carved out for irregular appointment. Now, my lord, the enforceable right would accrue when the appointment is against a sanctioned post, appointment is irregular as distinguished from illegal, and he has served for 10 years. And that 10 years was diluted in Amarendra Chandra Patra's case. So, my lord, therefore, we are entitled to a consideration. That's what in the other coordinate bench decision.
No, other coordinate bench said another thing. Is directing the state, saying that the states shall consider
Framing a scheme.
a regulation scheme. Now, for that, what subject to what you say, what the coordinate bench meant is when you frame a scheme for regularization, it has to be on the basis of a creation of post.
The posts are there, 71 posts has been advertised.
No, not these posts. It has to be. That is why it is said. The reason behind you see, what is regularization? You are bringing somebody who is outside the
Let me
fold of the government.
explain that part.
Yeah.
What had happened in the context of the other case I am saying. In Assam, there are about 234 and odd ICDS projects. Now, appointments are normally made, my lord, through APS. Now, they say due to administrative exigency, this contractual appointment was only for 1 year. Then they were extending and continuing till the judgment was passed. Now, the posts were there. Now, normally what would happen, my lord, those posts should have been advertised immediately within 4 months. Now, here in this case, if we go by the mandate of regulation 3F, if the post is likely to last for more than 4 months, immediately, my lord, the matter should be either sent to the FSC or to the selection board as the case may be. The state has not done that. On the contrary, state has utilized our service till then. Now, my lord, can they ask me to compete with a fresh candidate? That is the issue.
They have given you 20%.
No, my lord, even that may not, Lordship knows, my lord, this aspect has been dealt with by the Supreme Court. Even Supreme Court has given a judicial recognition to this fact that a whole person cannot compete with a fresh candidate. So, of course, my lord, to that extent, I'll have
No,
to
that
take
is why you are
instruction
given
also.
20%. A person will have to get 100%. You are already getting 20. You start with 20, the 20 handicap.
Anyhow, my lord, to that extent, of course, we'll have to take instruction from the client whether they are or they would like to go whole hog for the matter. That instruction I don't have. But my humble submission is, my lord, we have otherwise fulfilled the.
Because you see, Uma Devi is a case where it negated the legitimate expectation.
No, my lord, our legitimate expectation is within 4 months, if they would have sent the matter for selection, if we would not have been selected, we would not have any regret. But
So-
now having.
So
employed
then
us
you,
for 10 years,
so
11
now
years,
you have a legitimate expectation.
and now we have.
So
No,
that
Lord.
is the negative.
Now, no, my lord, legitimate expectation will give me a fair treatment, will not give me the absolute relief.
No, it will not be, it is not an absolute right. It depends upon the
The facts
facts.
of the cases. So my only submission is, my lord, since we are serving for the last 14 years, so might as well government consider it in terms of the other judgment. I'm not asking for any direction that our services should be regularized. My lord, tomorrow, my lord, if state is to refuse our case, then they will have to say why they are refusing. Then, my lord, the cat will be out of the bag. If they say that no, you have not fulfilled 10 years, we'll show we have fulfilled 10 years. If they show the post where you are working is not sanctioned post, we can show it is a sanctioned post.
Therefore,
there
they
is
are,
some-
no, therefore they are giving you 20%.
And that is a different aspect
No, no,
altogether.
the 10 years, whatever may be, the 10 years, the thing cannot be extended. Anyways, as I told you, you should take it up before any other bench, not me. I am very strict on this aspect.
I leave it to Lordship.
Because the only way out is they may give an advertisement, press advertisement for other 3F candidates. That is my
My
view.
lord, in this, in terms of the advertisement, if any 3F candidate has not.
No, you have to know, in terms with the advertisement only, but
Yes.
you have to allow
Yes,
all
yes,
3F. But they would not know all, if all are not here.
Yes, my lord, to that effect, a coordinator may be. Inspector.
Origin them, because there are many persons out there.
Yes, my lord.
Anyway, ages are okay, not so old,
All, my lord.
not old. Number 8 is 29. Number
now
9 is
today,
29.
29 plus 14
Number
will be
10 is-
43.
Huh?
Today 43, my lord.
No, read petition. You put the age, 29.
But 29 when we approached.
No, when you file the petition,
In 2019.
then 4 or 5 years.
Sorry, 2018. 19.
19.
I'm sorry, 19.
So it will be another 5 years, 35, with more experience, having a 20% more. In fact, Mr. Chaudhary, I don't think this is a case for, strictly speaking, regularization may not be a case here. You may go into that case wherein the judgment has been given for being considered as a substantive post, substantively appointed. But can it be said to be
But that
substantively
In
appointed?
fact, my lord, there is one judgment now, just now I remember, 2015-17 SCC, where Supreme Court says these are all alternative mode of recruitment. It's not that these are not illegal.
No, they are not illegal. They are irregular. They
Supreme
are,
Court
they,
has used the expression alternative mode of recruitment. This type of appointments, where there is some selection, some semblance of Article 14 has been complied with, then it is not to be treated as illegal.
But if the selection is not done by the
No,
authority
there were, my lord, the interview were there.
interview by, is it being done by the APSC?
No, my lord, no, that's what I'm saying, my lord. What prevented them from applying? Because it was administrative exigency. For the administrative exigency, the color we got was 3F. Otherwise, we would have got a regular appointment. That is one aspect lordship will consider. Today, we cannot compete with all these fresh candidates. That's the whole difficult.
Still have serious repercussions.
And my lord, all the TF appointees have applied, my lord, in phase 39, my lord, the forwarding is there, my lord. All the TF appointees have applied.
Page
Phase
39.
39 of the petition, my lord.
আমি সবে করা নাই এটা মানে সবে করা নাই ইনস্ট্রাকশন লুচি পেজ কিমান কলা
39.
43.
That's my lord.
Now, how many petitioners are here?
Here petitioners are 36, my lord.
36. So what about the other?
They have not approached before this honorable court, my lord, but they have
It's
applied.
okay.
They have applied already, my lord.
Hmm?
They have applied in terms of the advertisement, my lord.
They've applied.
Yes.
Has the petitioners applied?
Yes, my lord.
They've also applied.
some of them have applied.
Applied. Where can I find that all 43 had applied?
My lord, page number,
More particularly, those 7.
page 39.
Those 7 had applied apart from these 36. I'm only concerned with them. Because that is it.
Or as your lordship indicated that a corrigendum maybe it should indicating that if any other TF appointees are there, they may make an application.
And what is this page 43? Oh, this is Himachal.
That's what, my lord. This is a communication by the personnel department. In contemporary departments are even dated, I am director say government has decided that services of contractual appointees who have completed 3 years of continuous service at so and so may be regularized. It has further been decided that contract appointees were due to complete 3 years of continuous service on as on 39/17 shall be regularized after 39/17. Regularization be made after observing the all total formalities subject to the terms and conditions. The contract employees will be eligible for against the available vacancy. Reservation strictly on the basis of seniority subject to condition of eligibility criteria. Candidates should be medically fit for the post against which CC is being considered for regularization. Regularization shall be subject to verification of character and antecedent of candidate being considered for regularization as provided in so. This is of Madhya Pradesh, my lord, Himachal Pradesh.
They are good employers. Chalo. Let's dispose it of. But Mr. Kane Chaudhary, the learned senior counsel assisted by so and so appearing on behalf of the commissioners, Mr. D. Bora. DP Bora,
DP.
on behalf of the Health Department of the Government of Assam. The present batch of 36 petitioners have conjointly filed the incident with petition seeking a direction upon the respondents to frame a scheme for regularization of the services of the petitioners as dental surgeon and further seeking directions not to fill up the post of dental surgeons as held by the petitioners. From the materials on record, it is seen that an advertisement was issued. Where it- It is seen that an advertisement was issued not one, there are two
No,
advertisements.
my lord, one was issued earlier by APSC, but that was, my lord, not taken to logical length. Thereafter, my lord, this board was constituted. Then this advertisement was issued by the board.
Page 38 is the next advertisement.
Yes, is the impugned advertisement.
So then it is only 37. How did 43 get appointed? Post is 37. No, page 38 of the reputation.
38, 71 post were advertised, 71.
71 posts have been advertised, my lord.
This is the latest one which was put to challenge.
Yes.
So you were appointed against advertisement.
No, my lord, we were appointed against this available post, but we're not under regular selection, but by
No.
OPM.
No advertisement.
Our appointment, no, by advertisement. This advertisement at page number, my lord, 34 was in the year 2016. But that was by APSC, but APSC did not complete the selection. That's what the government has said in their affidavit.
Did you issue an advertisement?
43 have appointed. There was a selection process, my lord.
Selection process is different from an advertisement.
No, there was an advertisement also.
Advertisement, my lord.
There is no mention anywhere, anything.
Yes, my lord, para 2 of the writ petition.
Where does it say? There was an advertisement. In terms of an advertisement. Look. From the materials on record, it is seen that pursuant to certain advertisements being issued by notifications dated 22/11/2011, 31/12/2013, 13/10/2014, and 26/6/2015, the petitioners herein were appointed as dental surgeon under regulation 3F of the Assam Public Service APSC bracket LNF 1951. The said appointments the said appointments were made for a period of 4 months and were continued from time to time by granting extensions every 4 months. It is further seen from the reports that the government of Assam in the Health and Family Welfare Department after getting approval from the finance brackets SIU department by letter dated 24/8/2012, had sanctioned the creation of 1,640 numbers of posts in different categories, including 58 posts of dental surgeons in usual scale of pay as per the ROP rules 2010. Subsequent thereto, the Assam Public Service Commission on 14/5/2016 issued advertisements, an advertisement for filling up of 61 numbers of dental surgeons. Though a selection process was initiated and the petitioners therein had participated. However, the said selection process did not meet the logical end due to some complaints filed regarding anomalies in the selection process. Subsequent thereto, the Health and Family Welfare Department, by the notification dated 25/10/2017, constituted the Medical and Health Recruitment Board, for short MHRB, to make recommendations for appointment to various posts under the Health and Family Welfare Department, including the post of the dental surgeons. Thereupon, the record further reveals that the chairman MHRB issued an advertisement on 29/12/2018 for filling up of 71 posts of dental surgeons. In the said advertisement, it is very relevant to mention. It is very relevant to mention that from a perusal of the said advertisement, which is there at Annexure E to the writ petition, it has been categorically mentioned that weightage would be given to the candidates who are already rendering service in the Health and Family Welfare Department under Regulation 3F of the APSC bracket LNF Regulation 1951 and on contractual basis under the government organization. It has been alleged in the petition, the petitioners herein have contended that although there is a mention that certain weightage would be given, but there was no specification as to the manner in which the weightage would be given. It is further mentioned in the writ petition that the petitioner, after coming to learn about the issuance of the advertisement and with a view to participating in the selection process, had submitted the application before the authorities within the prescribed time limit. The Deputy Secretary, Health and Family Welfare Department, by the letter dated 30/1/2019, had forwarded the application of the petitioner for the 71 numbers of advertised posts of dental surgeons to the chairman of MHRB. Be it as it may, the petitioners herein, the petitioner's case herein, that as the petitioners have rendered service from their date of their appointment, respective date of their appointments, comma, the petitioners ought to be regularized in the services of the regularized and be substantively appointed to the post which have been advertised. It is under such circumstances, the petitioner has therefore approached this court seeking the reliefs have been sought for, as have been already mentioned supra. The record reveals that pursuant to the filing of the instant writ petition, this court, by an order dated 22/5/2019, issued notice no. Further to that, the consideration of the interim orders was also deferred to the next date. It is further seen that on 24/6/2019, this court directed that 36 out of the 71 advertised posts may not be filled up on regular basis in terms with the advertisement without the leave of the court. The interim order thereupon have been continuing from time to time. The record further shows that an additional affidavit was filed by the petitioners, bringing on record their subsequent extensions so granted to them pursuant to the filing of the writ petition. A perusal of the extension letter, perusal of the extension so granted by the various notifications shows that the petitioners have been extended in the interval, extended every 4 months. The services of the petitioners have been extended every 4 months. The record further reveals that an affidavit in reply, affidavit in opposition has been filed by the Health and Family Welfare Department. In the said affidavit, it has been mentioned that the government in the Health and Family Welfare Department moved the APSC for filling up of 60 numbers of vacant posts of dental surgeon by the communication dated 12/6/2015. That is, within 8 months from the date of appointment of the petitioner number 4 to 34, and before 13 days from the date of appointment of the petitioner number 35 and 36. Further to that, it is also mentioned steps were taken for carrying out the regular recruitment and to the post of dental surgeon, which were scheduled to be held on 24/10/2016 to 28/10/2016. However, the said could not be completed due to anomalies in the FPSC. In paragraph 9 of the said affidavit, it had been categorically mentioned that the weightage which is to be given to the 3F employees would be as per formulation of 5% marks for every completed year of service under regulation 3F, subject to a maximum of 20% marks of the total marks. It was also mentioned that as a matter of allotment of marks, as the matter of allotment of marks was confidential one, as such, the same was duly not mentioned in the advertisement. On the basis of the said affidavit, it was therefore submitted that the claim of the petitioner seeking regularization in the facts and circumstances of the case was not at all justified. In the backdrop of the above pleadings, this court have also heard the learned counsels appearing on behalf of the parties. Mr. K. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that the petitioner number 1 and 2, as on date, have already rendered more than 10 years of service. And as on petitioner number 1 and 2, and 3 have already rendered 10 years of service. It was also mentioned, Mr. K. Chaudhary, the learned senior counsel, submitted that the petitioners numbers 1 to 34, as on date, have already completed 10 years of service. He therefore submitted that by virtue of paragraph 53 of the judgment of the Constitution Bench in the case of Uma Devi versus
Secretary, State of Karnataka versus Mati.
Secretary,
State of Karnataka versus Mati.
Secretary and State of Karnataka versus Uma Devi. State of Karnataka versus Uma Devi reported in 2006 4 SCC 1. The petitioners ought to be taken into consideration for regularization as a one-time measure, as they had completed 10 years of service. He further submitted as regards to petitioner number 35 and 36, they would be completing this 10 years of service next in 2025. He further submitted that as the petitioners herein have been duly appointed against sanctioned posts. And by following a selection process, the petitioner's services ought to be regularized as the appointments of the petitioners can neither be said to be illegal or irregular, but are alternative modes of recruitment. If it is submitted that taking into account the judgment of the Supreme Court in Narendra Kumar Tiwari versus State of Jharkhand and others, reported in 2018 8 SCC 238, the state, instead of going for a fresh advertisement, ought to have first formulated a scheme for regularization or for absorption of the petition of all the 3F employees who have been duly rendering the service without any blemish. This, the state, being a welfare state, is constitutionally obligated to do so. The Learned Counsel, Senior Counsel, further submitted that in a recent judgment passed by the coordinate bench in the case of Hiren Chandra Das versus the state of Assam, represented by the Chief Secretary, Government of Assam and others, reported in 2024 SCC Online Guwahati 1880, the coordinate bench had, after consideration of all the proposed the various judgments of the Supreme Court, had observed that the respondent authorities may consider framing an appropriate regularization scheme so as to regularize the services of the petitioners as a one-time measure in the facts and circumstances of the present case. If submitted that as the facts involved in the present case are similar, this court also should pass appropriate directions to the state authorities for framing a scheme for regularization of the petitioners. In addition to that, the Learned Senior Counsel also submitted that the petitioner, as of at present, cannot be treated similarly to the fresh recruits, in as much as the petitioners have crossed certain age, and as such, permitting the petitioners to compete with the fresh recruits would not be an equality within the ambit of Article 14 and 16 of the Constitution of India. Anything more, Mr. Chaudhary? But actually, this is a case of a Monday, Wednesday, and Friday. Today I have no work much. So that is why I am taking time. Otherwise, it is a Monday, Tuesday. Mr. D.P. Bora, the Learned Counsel appearing on behalf of per contra, Mr. D.P. Bora, the Learned Counsel appearing on behalf of the respondents submitted that the petitioners as on date may have crossed 10 years of service. But the question is that as on the date of the appointment, as on the date of the advertisements, as on the date of the first advertisement, which was issued in the year 2016, submitted that as on the date on which proposal was invited for filling up of the post, the petitioners numbers 4 to 34 had only rendered 8 months of service, and the petitioner number 35 to 36 had only rendered 13 days of service. He further submitted that the petitioners had on the earlier occasion in the year 2016 had duly participated in the said tender pursuant to the advertisement, and have also in the present advertisement and have also in the present in pursuant and have also applied against the 71 against the advertisement issued on 28/12/2018, isn't it?
Yes, right.
Pusto. This aspect of the matter is very clear and is an admitted aspect from the perusal of the writ petition itself. Pusto. While the selection proceedings was initiated, the petitioners have now approached this court by filing a writ petition seeking a direction that the state respondents should frame a scheme for regularization of the petitioners. The Learned Counsel submitted that what the petitioner is claiming as on date by way of the instant writ petition have been negatived by the Constitution Bench of the Supreme Court in the case of Uma Devi Supra. The Learned Counsel submitted that that the Constitution Bench in Uma Devi had categorically negated the contention of the petitioners to be regularized in service on the basis of long continuance, legitimate expectation, employment under the state, and the directive principles. Under such circumstances, if any direction is issued for regularizing the petitioners on the basis of their legitimate expectation, the same would be contrary to the judgment passed by the Constitution Bench in Uma Devi. He further submitted that as to whether the state should formulate a scheme is absolutely within the domain of the state. And as such, it would not be proper on the part of this court to exercise the powers under Article 2 to 6 of the Constitution. He further submitted that as on the date of filing of the writ petition, none of the petitioners have completed 10 years. And as such, the question of applicability of paragraph number 53 of the said judgment in Uma Devi does not arise. More so, the cutoff date as stipulated in Uma Devi was 10/4/2006. As on that date, even the petitioner did not enter, none of the petitioners had entered into service. He therefore submitted that this is a fit case for dismissal of the writ petition. This court have duly heard the learned counsels appearing on behalf of the petitioners and have perused the materials on record. At the outset, this court, with the specific query upon Mr. D.P. Bora, the learned counsel appearing on behalf of the respondents, as to whether all the 3F appointees who would be given weightage in terms with clause 6 of the advertisement dated 29/12/2018 have applied pursuant to the said advertisement. The learned counsel submits on instructions that to his instructions that most of the 3F appointees have already applied. However, the respondent authorities are not adverse to issuing of a corrigendum, thereby permitting the other 3F appointees to apply pursuant to any orders being passed by this court. In the backdrop of this above, let this court consider as to whether the petitioners herein would be entitled to the reliefs as sought for. From the materials on record, it is seen that the petitioners herein were the petitioner number 1 and 2 were appointed in the year 2011. And the petitioner number 3 was appointed in the year 2013. The petitioner number 4 to 34 were appointed in the year 2014. And the petitioner number 35 and 36 were appointed in the year 2015. It is further seen that in the year 2015 itself, steps were being taken by the health department for filling up the 60 posts of dental surgeons, as per the provisions of under what provision?
My lord,
You must be having some rules.
my lord, that was under the APSC rules that time, my lord, 2016, my lord.
Under the
The advertisement is at, my lord, page
38.
34, my lord.
No, don't you have a rules? No, this is under what?
The APSC rules, my lord. that-
APSC rules. What is the name of the
I
rule?
think Lordship is indicating about the recruitment rules.
Yes.
It's like NLH more post here.
I'm just coming, just find out, huh?
Yes, madam.
What is the rule?
Yes, madam.
What, under what you are doing it? Recruitment under what provision? Steps were taken for filling up of the 60 posts to the Assam Public Service Commission. Full stop. In the year 2015. By issuance of a communication on 12/6/2015. Thereupon, an advertisement was issued on
My lord,
14/5/2016 for filling up of these 60 posts. 60 na? 60 posts.
And the first advertisement 60 years, 60.
60 posts. However, these selection proceedings, which were initiated on the basis of the advertisement dated 14/5/2016, did not materialize in view of certain anomalies in the Assam Public Service Commission. It is further seen that thereupon in the year 2017, by the notification dated 25/10/2017, the Medical and Health Recruitment Board were constituted. And pursuant thereto, on 29/12/2018, an advertisement was published for filling up the vacancies of 71 posts of dental surgeons. The petitioners herein have have also participated pursuant to the said advertisement. As would appear from paragraph number 8 of the writ petition. While the said process was going on, the instant writ petition was filed seeking the reliefs as aforesaid. However, the advertisement have not been put to challenge. From the above facts, it cannot be said that the Health and Family Welfare Department, the respondent department, did not take any steps for filling up of the posts. The question which, however, arises for consideration next is as to whether this court can direct the respondents to frame a scheme for regularization of the services of the petitioners as dental surgeons. For understanding the, for appreciating, for adjudicating the said issue. This court needs to take note of the observations so made by the Constitution Bench of the Supreme Court in the case of Uma Devi Supra. In the case of Uma Devi, there were two specific issues which fell for consideration. First, the right of of employees seeking regularization on the strength of long and continuous work. And secondly, the correctness of directions issued by courts for regularization of employees under Article 2 to 6 of the Constitution. The first issue as regards the rights of the employees seeking regularization on the basis of long continuance of service, comma, legitimate expectation, comma, employment under state, as well as the directive principles of the state policy, were negated by the Supreme Court, by the Constitution Bench of the Supreme Court. It was further held, while deciding the second point issue, that the courts under Article 2 to 6 of the Constitution would not be justified in issuing directions for regularization based on such features such as equality and long spans of service. In the case of the state of Jammu and Kashmir versus District Bar Association, Bandipara, a decision rendered by 3 judges of the Supreme Court, it was clarified that the judgment passed by the Supreme Court, by the Constitution Bench of the Supreme Court in Uma Devi, is not an authority for the proposition that the executive or the legislature cannot frame a scheme for regularization. Or in other words, it is absolutely within the domain of the state or as well as the legislature of the state to frame any policy for regularization. In the same judgment, it was also mentioned that regularization is not a source of recruitment, nor it is intended to confer permanency upon appointments which have been made without following the due process envisaged under Article 14 and 16 of the Constitution. Essentially, a scheme for regularization, in order to be held to be legally valid in terms with the judgment of the Constitution Bench of the Supreme Court in Uma Devi, must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigency. In paragraph number 26 of the said judgment in the case of District Bar Association Bandipara, the Supreme Court categorically observed that in the name of regularization, the state and its instrumentalities cannot be permitted to use this window to validate illegal appointments. Additionally, by virtue of formulation of a scheme for regularization, by virtue of a scheme, and additionally, the power reserved to the executive of the legislative to frame a scheme for regularization is not meant to create or invest in a temporary or an ad hoc employee the right to seek a writ commanding the state to form a scheme for regularization. It was observed that if such a right is being conferred, it would simply invigorate a class of claim which have been permanently shut down by Uma Devi Supra. Paragraph 26 of the said judgment being relevant is reproduced hereunder. Under such circumstances, in the opinion of this court, in view of the above principles of law as laid down in the case of District Bar Association of Bandipara, Supra, it would not be proper on the part of this court to direct the respondents to frame a scheme for regularization of the services of the petitioners as dental surgeons. As the said aspect is absolutely within the domain of the state and its instrumentalities to consider whether such scheme for regularization is necessary for the administrative exigencies. At this stage, this court, with great respect to the coordinate bench, would observe coordinate bench in the case of Hiren Chandra Das Supra would observe that the same observations so made in paragraph number 34 and 35 would be contrary to the principles laid down in paragraph number 26 in District Bar Association of Bandipara Supra. Next. This court also finds it very pertinent to take note of that the petitioners herein, pursuant to the advertisement issued on 29/12/2018, have duly participated in the selection proceedings. in spite of a prayer for regularization being made on 18th of February 2018. It is the opinion of this court that when the petitioners have duly participated in the said selection proceedings, knowing fully well that the posts wherein they were appointed were advertised, they cannot be allowed in the instant by way of a writ petition to annul the said advertisement proceedings, selection proceedings, that too without challenging the advertisement. Accordingly, this court does not find any merit in the instant writ petition. Next. In that view of the matter, the instant writ petition therefore stands disposed of with the following observations and directions. This court, the relief so sought for, directing the respondents to frame a scheme for regularization of the services of the petitioners as dental surgeons, is rejected. Number 2, the relief so sought for, directing the respondents not to fill up the post of dental surgeons held by the petitioner, is rejected. Number 3, the petitioners herein, in terms with clause 6, now the petitioners as well as all 3F appointees, in terms with the advertisement dated 29/12/2018, would be entitled to certain benefits, would be entitled to weightage, as categorically stated in the advertisement, in the affidavit filed by the respondent numbers 1 and 3, 1 and 3. The weightage to be given would be as per the formulation of 5 marks for each completed year of service under Regulation 3F, subject to a maximum of 20 marks out of the total marks. Number 4. It is seen that from the materials placed before this court and the submissions so made by the learned counsel for the respondent, it is not clear as to whether all the 3F appointees have applied pursuant to the said advertisement. Under such circumstances, this court directs the respondent number 4, respondent number 2, to issue a corrigendum.
No, my lord, that's my number 4, my lord.
Issue number 4, to issue a corrigendum to the advertisement dated 29/12/2018, thereby calling upon all the 3F appointees thereby giving an additional opportunity window of 15 days to the 3F appointees from the date of such advertisement to apply in pursuance to the advertisement dated 29/12/2018. With the above.
Well, it's 5% and 20%, my lord, not much.
5%.
5% and 20%. Maximum
5%
20.
and as per the years, up to 20%.
Deep level.
Mr. Chaudhary, your pleadings were also bad.
My lord.
Pleadings were also bad. It is an abrupt end. Interim orders passed earlier, stands vacated.
Admission item 6, fixed at 2 p.m.
My lord, there are three matters, 23 and 26. Can we take another date, my lord?
I don't mind.
When your lordship say
I
next-
started today's your matter also. Which one?
23 and 26.
Oh,
22 to
Mr.
26.
Chaudhary, you are there on the other side. These people, they were to withdraw. What is there?
No, but if somebody wants to withdraw, well, the problem is.
No. Otherwise, I was supposed to dismiss. You are respondent.
No, I'm for the petitioner.
Where? Oh, yes. What
23
case
and-
is there?
No, my lord, what had happened, their charging will, say Guwahati refinery rates are too high.
Understood. But what you have challenged out there is this.
No, my
There-
lord, the order, if there is an interim order. then
Interim
it's
order is no
subject
interim
to
order.
the outcome of.
Subject, understood. But tell me how this
No, my lord,
court can fix the
supposing
price.
I succeed,
Ah.
because there are two aspects. Number one, the government of India says that it must have relationship with the import priority price. So import price was on that day was 18,000. Whereas Guwahati refinery has fixed the price at 27,000. And it was brought down to 24 in the second round. And Dibboy refinery, it was 17 or 18. And Bongaigaon refinery was still less. Numaligarh was also less. In that view of the matter, this honorable court said that it will be subject to the outcome.
No, you said that, see your prayer. First, your prayer is, there is a circular of 7/12/2012 and 26/10/2012 to follow those two circulars.
Yes.
Now, as of now,
Yes.
can I direct that because of the fact that those two circulars have already been superseded?
No, my lord, the circulars which was holding the field on that day will govern the
Understood.
transaction.
So, as of now, I can't direct that in view of the supersession of that circular. I'm
Yes.
saying it. The second prayer, which is there, is that as regards the e-auction, saying that kindly recall the e-auction to be held on 7/5/2019.
No, that is the word. Question is, if I succeed, my lord, then the price adjustment will be there.
How can there be a network when you have not asked for refund?
No, my lord, the fact that, no, my
You
lord,
have participated pursuant thereto.
no, because because of this honorable court's order, my lord, if your lordship will kindly see that the auction will be subject to outcome of this.
Understood. Auction means auction has already taken place.
Yes.
Everything is over. Now, how anything remains out here today means, let us assume it will be subject to, that auction will be subject to. Money has all transferred, everything
If
has
your lordship
happened.
comes to the conclusion that fixing of the reserve price was against the government of India notification, then consequences will follow. Because government of India circular is there.
Then what is going to happen?
So my lord, if a lordship finds that the fixation of base price was wrong, then consequences will follow. They will have to return it
How?
Bec-
How?
because we have
Where's your
lifted,
prayer?
because we have lifted the scope on the price fixed by them.
So you have lifted is subsequent.
No, pursuant to the order, my lord,
You see,
No,
this
when
is
we have-
subsequent.
no, my lord, when on the day, they fix the price on the morning of the day of auction, my lord.
They
That's the
have
that's the
fixed it at,
difficulty.
they have fixed it at 28,000.
No,
Now
yes,
you-
subsequently it was 24.
28,000 or whatever it may be. The case which has happened earlier was, there was an order being passed by the another court date bench, this is Bhuiya's order,
Yes.
wherein he never said that you fix it in this month. We can only
Sir,
request.
Earlier, Condon bench said, my lord, you must follow the government circular.
No, it said that we can only request. See,
Okay. Yes, page 29. In the light of the due the application is directed to reconsider the reserve price for RPC for immediate e-auction to ensure it is more or less at par with the other refineries of the state.
Then
Page 30, my lord.
it is, what is the, that
Page
is,
30, item number 23, na? Page 30, para 12 on top.
in the light of the.
Above and on due applicants are directed to reconsider the reserve price for RPC for immediate e-auction to ensure that it is more or less at par with other refineries of the state. After so fixing the reserve price, the e-auction may be commenced. We say, my lord, this was violated. and
No,
Government
no,
of India
this is an interlocutory order. But this has been disposed of. Hey,
No,
first I
no,
think-
my lord, there was an interim order. They filed an application for vacating on that this order was passed.
Kindly
But this
say-
order has attained finally.
Well, not a window. That is an interim order.
No, this was an order passed in their IA, my lord. No, interim order, interlocutory IA ke kon disposal korche. My lord, IOs were filed by them for vacation. Subject to the above, interim orders are vacated.
This order was passed when?
It was passed on 30, my lord. 30/5/2019.
Now kindly come to another order passed in another petition,
Yes.
that is WPC number 491/2019,
So I think that I think
wherein you also appeared.
that was an earlier order, I suppose.
Ah.
But this was the last order. We say, my lord, this order has been violated and 7512 guideline has been violated. So there was a positive direction that it should be more or less. We don't say that it should be across all the refineries should be same. Some variations.
And this
there.
direction is for the immediate e-auction.
Huh.
This was not the next direction.
Following that is the one in which we are concerned, my lord. Then page 36 is the e-auction. 7619. Order was for 3519 and 7619 is the auction. Just after, my lord, 8 days. Page 32. And reserve price was not mentioned, my lord. On the day of auction in the morning, they mentioned. It is in that context, my lord, we have no clue as to what would be the price. Then, my lord, when sale intimation was given, then we got to know at page 38 that the price was 24,150. Earlier, it was 27,000.
This is an IA. What has happened to these petitions?
My lord.
What are these petitions?
No, my lord, those virtually the repetition was closed by that order in the earlier round. Because there was an initial and interim order.
No, there were some interim orders passed in these petitions. These petitions are, IAs are passed in which petitions?
Amar case of PIC person.
Because kindly come to
No, my lord.
the earlier order of 6/2/2019.
Page 21, I suppose, my lord.
I think.
23. My lord, page 23, 9519, there was an interim order.
Not this one, not this one.
Yes. Page 23 is the interim order, which was my lord, modified.
Prior to that, there is another, Mr. Sahewala, your matter. Just show him that where he only appeared. Mr. Chaudhary only appeared in that. Page 32 of Mr. Sahiwala's matter.
44, my lord.
Kindly come to page 35.
35, my lord.
Page 35.
It's a special terms and condition.
No. This matter, who is appearing? 5703.
57.
India Carbon. This is where he has finally disposed of. Mr. Chaudhary, you had appeared for the writ petitioners there.
My dear Lordship. I think, my lord, all the cases were taken together. All they were together. That's why my name appears. India Carbon is there. Then Guwahati Carbon is there, 478.
Kindly come to the last paragraph 15 of that order.
Yes. NRL is but though it has to generate revenue and earn profit, at the same time, it is also to ensure local prices are not put to any disadvantage by keeping reserve price of RPC in any auction quite high. While stand of the NRL that the reserve price of RPC is in the next auction will be kept lower than the reserve price of RPC auction by Guwahati Refinery is certainly welcome and appreciable. It may also examine feasibility of scaling down the reserve price of RPC, keeping in view the import price of RPC.
Then,
Beyond the observer, it may not be provided court to venture into yes. Court hopes and trusts, and I will look into the above aspect of the matter conducting. In fact, madam, NRL brought down the price after this. But Guwahati Refinery has not done. Now the present batch of challenge is pertaining to Guwahati Refinery.
now, if you have participated,
No, what now the situation is like this, my lord. A lordship has noticed the order at page number 30. Then, my lord, the auction took place on page 32. Kindly see the reserve price was not fixed, page 32, on June 7, just after 8 days. On top right hand side is the date, June 7, 2019 at 5:17 p.m. Refinery offered, there is no reserve price, 12,000 MT.
page 31.
Page 32, my lord.
Yeah.
32. This was the my lord auction notice. Refinery Guwahati, quantity 12,000, no price mentioned.
RPC. That is the product.
In the earlier they had mentioned the reserve price, my lord, at page 31. 15,400. But in the page 32 notice, which was issued on June 7, no reserve price was given. Then my lord will kindly come to page number 38. On the day of auction, my lord, when we were shown to have been qualified, they show the price at 24,150. And we were given 5,000 MT. We are pleased to inform you that your bid against the following item mentioned have provisionally accepted, subject to approval by seller. Seller reserves the right to accept, reject the same. So that stage only, my lord, we got to know.
So you auctioned on 7/6.
Participated, my lord, pursuant to page 32.
Okay.
We participated, we never knew the price. So by page 38, we were informed to the extent of 5,000 MT, your offer bid has been accepted and price would be 24,150. It is in these circumstances, my lord, the Honorable Court by way of the interim order said that this fixation of 24,150 will be subject to outcome of the case. And now, in view of the earlier judgment where the Honorable Court said, my lord, it must bear some resemblance with the import parity price and the circular of the Government of India. Now, if we succeed, my lord, then the consequences will follow. Now, my lord, if your lordship would kindly have a look at the stand of the refinery at page 2 of their affidavit, para 5. Eco refinery আছে 15,400 হয় জানো?
Who is the reserve price? My present of
So this order was passed on 35/2019.
Yes,
So as on that date,
Ah.
you did not participate.
No.
Okay. Thereafter, you participated.
I participated pursuant to page 32 below.
But,
when-
tell me about this writ petition. Where is the writ petition? This is only an IA.
No, no, Miller, WPC 3880 of 2019,
Which one?
3880, item number 23. 23.
No. This is a writ petition which was filed subsequent thereto.
Yes,
I'm not on that. These orders passed by Justice Bhuiya are in interlocutory applications.
yes.
Where
That,
is the
that was
main
in
writ petition?
WPC number, Millard, 2966 of 19.
2966 of
And
2019.
2971 of 19.
What has happened? Is it pending?
Pending.
2966, I think yes. What happened to this matter?
My lord, orders were actually disposed of, my lord, that technical information where physically it was disposed of for some cycle. 2929.
Because there was a stay. So this stay was vacated, subject to reconsideration by them for a year,
Yes.
for a year.
Yes,
Then they made it 20, how much?
page 32, my lord. No, they don't fix the amount.
But then also it is less.
Yes, no, my lord, no, not, it is not less. Earlier it was 27,000, they brought it down to 24,150. Whereas, my lord, same Digboy refinery, 15,400.
No.
Yes,
Kindly come to page 29,
yes, my lord.
paragraph 11.
Yes, these are the different rates.
Yes.
If the reserve price of RPC at Digboy refinery is 19,200, Bongaigaon is 19,000, so and so, it defies logic as to why reserve price of Guwahati refinery should be 27,000. Yes, at that stage, this was the position.
So far as NRL is concerned, it
Ah.
had earlier fixed the reserve price of RPC at 28,300 per ton.
But
But
after
after
the
the
court's
order, it was made to 21,300.
yes,
Now they have made it 24,000,
150.
150.
How can, my lord, IOC, the same company? Now, if your lordship would kindly come to page 31, that was by Digboy refinery, it was 15,400. Same company, same refinery, Digboy
What
refinery.
is their justification in the affidavit?
Yes. Now, Milord will kindly come to para 5 of their affidavit.
Lordship may kindly take up my last, the last case, my lord, is item number 22. Wherein, my lord, we have stated all this thing, that is WPC number 5703/2009. Item number 22.
Milord will kindly have
57?
para,
Item number 22, my lord.
57?
5703.
it is not.
What have you stated?
This was the last, in the series of the cases, last one.
Affidavit 4th of September 2019.
Yes.
What have you stated?
Lordship may kindly see first, my lord, page 2, paragraph 4.
Ah.
Regarding, my lord, e-auction process.
RPC means what?
Raw petroleum coke.
So they are concerned with the floor price. What is the basis? How do you regulate the floor price?
Interim order. It will interim ne final order.
So the grade in Guwahati is better.
Better. That is why, my lord, this is the region, my lord, they do not want to live from other refineries. The purchaser, they are also taking the, my lord, they are not the public, they are also definitely, my lord, seeing their profit. If, my lord, they purchase from the Guwahati refinery product, then they will, my lord, benefited in producing their own product from the. Then your lordship may kindly see paragraph 6.
I've looked into it.
My lord,
No, you have reduced it by 2,400 or 870 per metric ton.
That is, my lord, honoring the court's order.
my lord, if your
Although,
lord-
my lord, that could not be done, my lord. But honoring the court's order, my lord, that has been reduced.
Now, how do you
But it
fix the
cannot be- it
floor
cannot be,
price?
my lord.
Now, how do you fix the floor price?
That is a confidential issue, my lord. That, my lord, lordship may kindly see.
No. I am not asking you how confidential issue to that effect means who does it. I am asking you what is your modus? How,
My
means
lord,
what are the parameters?
Page 3, my lord, of my affidavit.
Ah.
Refinery was D, clause D, my lord.
Hmm.
Refinery was floor price for RPC workout in the line with the MOPC and MG guidelines by the Empowered Pricing Committee, having members from the institutional business, pricing and finance department at headquarter office IOC. This working is vetted by the head of the pricing at Indian Oil Corporation Finance Department head. And then it is approved by the head of the institutional business of the Indian Oil, TGM, IC, Swatch.
So this is on the basis of some MOP and MZ guidelines.
That is, my lord, that guidelines, my lord, 7/5/2012.
7.5.
2012.
So that is the guideline. Wherein it says that that is the on the basis of that guideline, empowered for pricing aware having members from international business pricing and so and so. So this is how you fix the flow price.
That has been disclosed at the time of my lord.
That is a different thing. I'm not on that. But this is the modus. And they have to submit an EMD only at
Right.
700 per metric ton.
And guidelines said, my lord, in the, it is clearly mentioned that the ensure maximum revenue import parity price with freight charges, quality differentials, that is also there in the guidelines, my lord, marketing costs and margin and other necessary adjustments. That is
Where are you getting?
from the guidelines, I have quoted in my lord, page 4, my lord. Page 4.
Where?
Page 4, my lord, first line, the guidelines dated 7/5/2012. Their allegation is, my lord, we are not following the guidelines of 7/5/2012. Regarding sale allocation of raw petroleum coke RPC under the said guidelines.
So
It
there
has-
is a expert body to look into it. Why should this quote on the 226 look?
My lord, can I respond to what my learned friend has said just now, my lord? Please have a look at order dated, my lord, 22/6/2019. In this proceeding, small order, my lord. How they have defined these orders in the present proceeding. 22/6/2020.
Yes.
My lord, same crude, somewhere they produce something, somewhere they produce X, Y. I'm not reading the first para. As required by order dated 1/6/20, a confidential communication has been provided to the court, which shows the basic price and the floor price that were accepted in some of the auction dates. The basic price is stated to be import parity price, and the floor price is stated to be floor price that is taken into account in the respective auction. Reading the confidential communication would show that basic price, what is stated to be the import parity price, is at variance from the floor price that were taken into account on the given respective auction. The policy as depicted as in the communication dated 7/5/12 provides that to ensure maximum revenue, the import parity price with freight charge, etc., 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 should be used as the floor price in the bidding auctions. Accordingly, it is to be understood that import parity price, which may include the freight, etc., 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 and margin and other necessary adjustment, should be the floor price in the auction, prices. In other words, whether import parity price was arrived at by respondent IOCL in respect of given auction should be taken to be floor price in the auction, and the floor price taken can be of any figure higher than that. Being prima facie satisfied with regard to the contents of the policy provided in the communication dated 7/5/12 in the interim, it is provided that if the further auction, further auction is conducted by the respondent IOCL in respect of Guwahati Refinery, the requirement of the policy contained in communication dated 7/5/12, that is the floor price should be import parity price, be strictly adhered to. So this order was binding, my lord, when this price of 24,000 was fixed.
So therefore the question would be, if you are fixing, this order was binding, how? This order happened later on.
No, my lord, this is the interim order in this proceeding.
But this happened later on, much later, didn't it? This order was passed in 2020.
those funds.
No, but the question
Anyway,
therefore,
that's the interpretation.
therefore, Mr. Sharma, the question is therefore, as to whether it was in accordance with 7.5.
Yes,
That is the question.
yes, yes. We are following the 7.5.
Okay, now the question is whether it was the import parity price had with freight price, quality differentiation, marketing cost and margin and other necessary adjustments form the part to form 24,170.
These are the
That's-
guidelines.
That's the question.
Yes.
Why should we go this way or
Yes,
that
fine.
way? So you can just.
Other submission before your lordship.
Other this court, you see, the question does not arise anything else. As of now, we are to only consider that aspect. Make it very small. Why should I go into all the other aspects?
Precisely. And
Because
if-
as of now, you have a different circular. These have
Yes.
been superseded. So as on that day, this circular had 7/5/2012. We are not going to question on anything else.
Yes,
But was it done in terms with the?
yes, madam. That has been done in pursuance of the 7.5/2000.
Was.
That was done, my lord. That is the stand of the, my lord.
Was that you can see that from the price. As of now, there is nothing confidential on that day.
Fine.
As of now, is there any confidential?
My lord, that, my lord, has been produced before your lord, before this honorable court on the earlier occasion, confidentially. My lord, how the price was fixed. That was the.
No, we are not concerned with that, but whether the price was fixed in terms with 7.5, that is the question.
My lord,
You can't fix anything else because this is this is by the government of India.
yes, guidelines has been duly followed, my lord.
Very well, if it was followed,
My lord.
bids may be invited from both within and outside the bid, and if any surplus or is still available, the bids outside the area will be open. So 7.5 has to be followed.
Yes.
So if it is 7.5 is to be followed, you produce that. How did you fix 24,170?
Yes.
That is over. There's nothing to be confidential now. Is it confidential? Who is appearing for the Ministry of Petroleum?
My lord, CGSC, my lord.
No CGSE.
Lordship, my lord, which was produced before this honorable court earlier, confidentially, that is with me, my lord. Lordship may kindly look into it. 22 to 26.
So therefore, give us the calculation
Yes, my lord.
as per that.
This is the calculation. This is the calculation.
No, it is not the calculation. You say the basic price was 19,031. And you say that the floor price was arrived at 24,150 on the basis of adding these as per the Ministry of ER.
Doing all these things.
So you will be having those details. We are not asking for anything else. And I don't see how can there be a confidential. You may have a confidential floor price today. As on the date, no, Mr. Sharma, kindly appreciate.
There is no auction system nowadays.
Whether you have an auction or not, I'm not concerned. But how did you arrive at 24,130? You categorically say that the base price was the import price. So after that, you can add freight charges, quality differentiation, marketing costs, margin and other necessary adjustments. To bring that details, that is how you have arrived. Or is it something that, okay, we are having 19,030. And thereafter, Mr. Sharma's fees is too high, so we put some more amount out there so that to compensate us. Is it something like that? So tell me. What do you say, Mr. Chaudhary? There must be the consideration otherwise.
They said, my lord, this is the fixing of floor price is a confidential matter, my lord. My lord, that is
As of now, you don't have auction.
no, my-
So why any confidentiality? And what is the question of privilege? You have to claim privilege. Kindly see one thing. You have to claim privilege. And if you claim privilege out here before this court may allow or not allow. Ek karla.
that's up to your lord.
Then I don't allow this type of privilege.
No, no,
And
absolutely, my
therefore,
lord.
as of now, you don't have. You want us to be transparent. After the floor price being fixed, I understand that tomorrow you are having a particular
Auction,
auction. So you may keep it confidential now.
yes.
Very well. Taking into account because the bidding has to happen. You may require something more than that because floor price is the base. You cannot give below that. And thereupon any bidding goes to 10,000, 15,000, 35,000, that's a different aspect.
Safeguard, my lord.
Yeah.
That is one type of procedural safeguard.
Safeguard, that you have to get this.
My lord, the whole basis of this, all this litigation, my lord, was the order passed by initially in the NRL case, page 35. If we go to the conclusion of the NRL case, my lord,
Mr. Sharma, let me tell you, I have nothing to say to that effect that this court, in my opinion, cannot direct you to reconsider. No. The question of reconsideration by you does not arise. Whatever may be, the reconsideration can only happen is in other matters, but not as regards the price fixation. If you are having, just for example, if you are having 10,000 rupees as the floor price, you have to have the basis as per the guidelines. This court, in my opinion, whatever may be 226 is not a jurisdiction to make it to 88,000.
one of my.
That is your submission. So I'm not concerned with those. My therefore question is, how did you arrive 24,150? That's all.
I have to take instruction on.
Get your instructions on that. That is the only
that.
issue.
Absolutely.
Now, let us, if you, Mr. Chaudhary, another very important basic thing. How do you get any benefit from here?
No, look, we were looking at a slightly,
No, without
picture.
amending your writ petition. Let us assume that they have made it more. What do I do?
so in that case, we are entitled to refund.
How?
My lord.
You have not asked for
There is no prayer in any of the. No, no, my lord, no, my lord,
refund, mafatlan.
there is always a scope for molding the relief, my lord, in a 226 proceedings.
There the problem, right? That is why I say that the initiation.
Technically, yes. Technically, yes. But my lord, if your lordship takes a broad view of the matter, at times lordship can also. Lord, it can't be said.
I would have. If I'm taking up the pension bench, I would mold and do many things. I'm taking up land acquisition, then I do very thing. Subject to not
No,
India
no,
governs land
I
acquisition.
quite see it, my lord, if necessary, if that is the situation, if during the course of the argument, it transpires that what we are saying is correct, then we might come up with some prayer seeking our lordship's leave. Without adding to all these things, my lord, without trying to argue on the one.
And how much did you quote? How much did you take?
My lord, we had
How
no
much
option.
did you
We had
pay?
the amount only.
Now, how much did you pay?
5,000 into, my lord, 24,100. It runs into.
These are all questions of facts out there. Anyways,
We paid, my lord, 12 crore, no, 1 crore. 20 lakh, yes, 1 crore, 20 lakh, 75,000. That was security hai. Well, the amount we can work out the figure, my lord. Hobbies. It will do 10%. It comes to my lord 12 crore 7 lakhs 50,000.
Mr. Chaudhary, let us see your prayer.
Yes.
Otherwise, why should I keep these people? Now, prayer number A1 should not be issued for interfering with the aforesaid arbitrary and illegal action on the part of the respondent in not fixing the floor price in terms with so and so. Now, this has become infructuous.
Yes.
Should not be issued for interfering with the aforesaid illegal arbitrary action in not fixing the floor price of Iman as mandated in so and so and so and so. Here they say that we have reduced it as per that. Till then, there was no order which Justice Buzarbura passed. Pursuant to setting aside and quashing the e-auction for sale of 20 there, this has finished. Forthwith conduct a fresh e-auction in respect to RPC, finished.
Six survives.
Mr. Chaudhary, no.
No, my lord, if a situation comes with the leave, by taking leave from your lordships, my lord, perhaps, my lord.
Very difficult.
No, technically, what is fallen to my lordship is correct, my lord, but that depending on the.
In fact, what should have been, if the matter would have been taken then and there, this is a question of price fixation. It should have been taken then and there and finished it off. And asked him then, okay, 7.6, they have done it. You have done it 24,000, why don't you produce that? In fact, that document which he has produced doesn't say head and tail. And what is the confidentiality of that document? There's nothing out there. Because what does it say is, the base price is 19,030. We have added as per the Ministry of this petroleum and all, the water circular we have added and arrived at 24,000. What are the others is not there.
What are these as a classification of those amounts?
Amount. So this is should have been there. And what is the confidentiality?
I will show for regarding fixation of floor price. I would like to place one judgment, my lord. It is the prerogative of the, my lord, in the Punjab and Haryana High Court judgment, my lord. But you may kindly have a look on paragraph, my lord.
Mr. Sharma, no appeal lies from here to Punjab and Haryana. Don't come. Well, get the instructions on this. But Mr. Chaudhary, you don't have a problem. List this matter on 12th or 16th of December 2024. Full stop. On that date, Mr. D.K. Sharma, the Learned Standing Counsel for the IOCL, shall place instructions as to how, what were the shall place before this court the instructions as to how the amount of rupees 24,150 was arrived at as the floor price for the auction which was held on 7/6/2019. Full stop. It is seen from the records that the base price, the import price was rupees 19,030. Full stop. The respondent authorities shall place before this court the other details with specifics as to how the amount was arrived at rupees 24,150.
Instead of 16, could it be 17 million? 16? 17 million. Deep look.
Only that, nothing more than that.
Item 6.
Oh, yes. I thought this is Mahalakshmi.
The only difficulty, my assisting counsel has gone for a meeting,
Lenil.
for a meeting. I don't know.
Oh, this is refrigerator. Huh? Ini. Huh? Tak lagi. Telugu. Itu Karnataka. Itu ada hadis. Okay.
Anyway, no, 16,
Nobody wants to do.
16,
Huh?
16.
No, no. 16, so many matters are
Seven.
listed.
18.
Why do you want to before vacation? Yes, madam, tell me.
Alon will kindly take up this matter, ma'am. On 16, 17.
Oh, what happened to the PETA matter today?
That's the same. It
Huh?
was on
It
top
was
of the
fixed.
list.
You fixed it
No,
today.
it was in the top of
I
the
was
list.
asking, thinking about getting it in the top of the list. I was thinking
But
what
it
to
went-
do with that bulbuli birds and buffalo fights.
But it went
Huh?
to,
Where is
on
it?
top of the list, it went to a different bench.
Oh,
Then I, one of the junior,
God save me.
where we thought of finishing, my lord, of that matter.
Very good.
Lordship will kindly take up on 16, whichever is convenient for you.
This one.
Yes.
16, many matters are there.
No, when 17, 18,
Huh?
whichever is convenient.
Impossible. Chalo. Because these will be the motion days. All these will be motion days, 16 to 18. Anyways, okay. 18. Yeah. List this matter again on 18/12/2024. Let me at the top of the list. You have an urgency.
Friends,
The urgency we have.
You will have it at top of the list.
yeah. It is
At the top of the, huh?
uttered.
What? I have not heard it. I only know
No,
about
no,
the
Lordship,
refrigerator.
that day, your, no, whatever result it may be, my lord, your lordship has heard this matter that
I
day.
don't know. I know about the only the refrigerators.
No,
So
no,
that if I make it parted in a live streaming court, people will laugh.
no, not
Like it was like yesterday, Mr. A. Ganguly was asking me that Lordship may allow me to amend the writ petition. I said, you have filed an application. No, my lord, verbally.
That's, I think, Punjab National Bank case.
You were the L1
I was elder.
and the petition was found to be the valid L1. Then it was not given to you.
No,
Why?
they have not given, they said that there is not corrigendum because there was some objection which was raised by some of the bidders. He was not also L2, L3, L4. They said that no, the specification which was given that WHO has to be there, not ISO. Because what they said, there is an advisory in nature where it says that ISO mark so and so has to be followed. And if you go outside that, you have to take permission from the Government of India. There is a provision where there is a query which was made by them in pre-bid meeting. One of the unknown, he was not a participant of bidding process also. He said, no, ISO will not do. WHO, who is having the WHO only, they can, that particular, they have
So was it a part of the tender condition?
ISO / WHO.
And now they insist that WHO has to be mandatory.
They are mandatory by somebody in the query, some query and a remark.
Let us see the tender condition.
Yes. Kindly see the NIT, my lord. NIT has page 43. 43 is the NIT. And kindly see at page 53. C 53, 47. Eligible, eligible participating 47. At page 53.
Eligibility.
Eligible participating kind is 7. The cold chain product may be tested at ISO accredited laboratories so and so. Now, the Lordship will look into page 56. Now 56, checklist to be submitted by tender. Now at page 58, this is for
Product tested at ISO 17 approved laboratories, public WHO.
OPQS code slash. Now,
Certificate at ISO approved laboratories, public WHO PQS code.
yes.
Okay, then
Now my lord will kindly see at page 60,
product tested certificate of ISO
disclaimer kindly see.
approved laboratories, public WHO
Yes.
PQS. Okay, then
Now my lord will kindly see one advisory in nature which is mandatory. Your lordship will find
product tested certificate at ISO approved WHO. There are no standard mentioned. This certificate, thus we request you to revise this to WHO. Be qualified as what is this specification annexure C?
yes,
Service specification.
yes.
Who issued?
Specification, my lord, there is a query which has been
Right,
put.
so this was changed.
This was changed, this is not by way of corrigendum. It it is not by a corrigendum, neither it is amended.
Ah.
This is what a query was, some query was raised in a pre-bid meeting. Some unknown, this is not a bidder also, some unknown, it is their affidavit. He raised this query. And this query, kindly see, my lord, thus we request revise this as WHO PQS pre-qualified with valid PQS code. List of so and so, they are listed currently local manufacturer will participate taking advantage, unclear specified mention. Remarks, now kindly say remarks. Product compliance modified to WHO PQS pre-qualified with valid PQS code standard for ILR. Now that is only a remark which it in the portal, but they did not change by way of a corrigendum, my lord. They never changed it by a
Who
corrigendum.
is Rockwell Industries?
Yes,
You are.
yes.
Petitioner.
I-
is the Rockwell.
As per the reply to your representative,
I
it
am
should be
the-
mentioned that
I
the
am the
compliance
agent
fee is
of
mandatory.
Rockwell.
However, no corrigendum was issued for the same. Takes pride into made in India product and we are committed to meeting of to bring to a that the product is we have to then
Now,
your offer was rejected.
my offer is not rejected. My offer is accepted. I am L1.
Then?
Technically qualified. Kindly see 49, my lord, page 49. This is important, my lord. 49. Kindly see notice inviting to the first paragraph. Director comes Chief Executive Officer Livestock Health and so and so. Assam invited a bid through the government marketplace GM portal for supply of so and so. Ice lines as detailed below section 1 and 2 under cold chain component of the National Animal Disease Control Program. The specification must not dilute. Well, kindly see the word must not dilute the advisory program of cold chain by the Department of Animal Husbandry and Dairy Government of India White so and so dated 28 March of 2022.
You are Mahalakshmi.
Mahalakshmi.
Who is Rockwell?
Rockwell, I am the agent of Mahalakshmi. I am the
Rockwell and
agent of
Mahalakshmi is one and the
Rockwell,
same.
of Rockwell. They are the original equipment manufacturer. So tender can be participated by the original equipment manufacturer or by their agents. No. Now, your lordship kindly see.
Then what happened? Problem, where is that problem?
No, what has happened, my lord? Technical bid, my lord, they have gone with a technical bid. Technical bid, I qualified and the financial bid was also open. your lordship kindly see, technical bit at page 65.
The problem is where?
Problem is that, my lord, they decided, after my financial bid was opened, my lord, on 15/3/2024. Now there was, my lord, the code of conduct came. They could not place any order. Thereafter, after 15/3/2024, Voltas, they came up and they filed a representation before the authority on 23/3/2024. That how can a technical bid, how he qualifies technical bid? But they were L1, their agent was L2, L3, L4. Now they said, no, it cannot be. Because,
They are WHO compliant.
yes, they said, they are also not WS compliant. Kindly see,
Who is paying for them?
nobody is appearing. We have given only, they are not appearing. My lord will kindly see the affidavit of the government, which makes it very clear, my lord. Kindly see the affidavit of the government.
Now tell me, if you are technically now not qualified.
Yes.
Then a right is conferred upon somebody. A right is conferred upon somebody.
If technically,
If you are technically not qualified,
yes.
as per the impugned order, a right is being created upon somebody else to get the tender.
Right hand on, they said what they decided in a meeting, they call everyone. And they said, we have decided to cancel it and re-tender it again. That's what decision they have taken.
Logic, there are some technical problem, Logic. Initially, in the tender, the eligibility criteria was actually ISO, that particular certificate. That is a general requirement. So after that, when we give it in the GEM portal, there is an open position for 4 days, where anybody can, it is open for everyone, anybody can give their complaint or their some whatever they can give, and some 2-3 persons have already given their representations, which we have disposed, where one of the representation was there that it should be of WHO PQS certificate. So we have considered it and accepted that request. And we have given it in the portal. In the remark column of the portal, we have mentioned it, that we have amended this from ISO to the WHO.
Was it before the submission of tender?
Before the submission of the
Before submission.
before submission. And after that, when it was closed, that 4 days window was closed, after that, all the bidders have participated through the GEM portal. Afterwards, Lordship, what happened that when the technical bid was open, at that time, all the private respondents, they have come with a representation again that it is not proper to give this type of a certificate because it is a upgraded certificate, and then the competition will be very less. So after a discussion in the meeting of the department, they decided to change it as optional, either ISO or WHO PQS. But what is the problem there is that when it is in the meantime, technical bid was already open. So after opening of the technical bid, it is not possible to mention it or amend it in the GEM portal. That's why the second option which we had opted was not given in the updated Lordship. Yes, it is.
So you want to make it optional.
Second time, we want it as option. We want to amend it as optional.
So which you had in the initially also.
Initially, we want only ISO 17, that particular 170.
Initially.
Initially.
But certain documents show that at page 53 onwards, it was also mentioned WHO.
Yes.
Yes.
I need see more particularly this page 757. Product tested certificate for ISO approved laboratory WHO PQS.
It's the NIT, the original NIT, it was mentioned as the ISO certificate. We required the ISO certificate.
No, both. Didn't it? Page 57. So serial number 6.
It
Serial
it
number
was
7.
optional. At that time, it was optional.
So therefore now you want to again make optional.
It's optional, but it is not possible when the technical bid was open.
But
So we
isn't
can't-
it optional? On page 57.
It was earlier, it was optional, then we amended to compulsory to
So
WHO
you
PQS
made it
certificate
compulsory by way of a comment.
by way of a comment.
So now therefore you are going to cancel everything.
Cancel not for that, the lordship. And afterwards, when after opening of the technical bid, it is not possible to revert back to the original NIT, that optional one. We can't open, then only when we open the bid, technically the petitioner was non-responsive. But due to some technical error, perhaps it was mentioned, it was reflected as responsive in the GEM portal. And as it was in
It
the
was
technical bid,
non-responsive because of the comment.
because of the
Comment.
certificate, because of that certificate. Afterwards, as he was, the L1, as he was participated, he was responsive in the technical bit, whether it was due to technical error or whatever, he was responsive in the technical bit, so he went to the financial bit, and in financial bit, he was L1. So in that, at that time, the other three respondents, they have given a complaint in the department. So now the principal secretary of the department called all the 4 bidders who were qualified in the technical bid, that-
Including the petitioner.
including the petitioner, that we want to cancel this bid process, because if we are now going to revert back to the original one, then also the other petitioner, the private response, they will come again before with a complaint. So
What is the requirement as per your, this is a sponsored project.
this is a central government project, lordship.
What do they require?
They actually, central government, they require their benchmark is the ISO, the original one. Their benchmark is ISO 17024. That was, but that is the minimum requirement. We can go up any extent. lordship.
So now it is because of the intention of the principal secretary.
Of the department, that if there are some problems and difficulties from the department also, because if we now consider the petitioner, then also there is a problem.
Mr. Das, what do you say about how the GEM portal changed? What is the effect? Because if I remember the GEM portal, they have a particular guideline. You looked into that?
I have not, I can look at.
Well, look into it, because I remember I was doing just before elevation, I was doing a matter out there. The GEM has a particular guideline. So the guideline categorically mentions how changes can be effected. Now, whether that change which they have made it had an impact or would have changed the terms and conditions, we also reach out.
No one.
Because her problem is, I understand, her problem is they want an optional, but thereupon somebody told, so they gave up and came up with this, but before the technical bid was open, people thereupon submitted. Now, thereupon, now they realize you have become ISO here, which did not have that. Technically, it should have been cancelled in a non-responsive, but what has happened now is they want to go for a more bidding process so that ISO and both will come into the picture. So therefore, they can't do it because of that comment. This is the hurdle is the comment.
But that
So you-
comment which has been made, this is not a bidder has complained. It is their own affidavit. Some outsider has made a comment. And then,
No, that comment which was there, Mr. Das, have a look at the
I
jail.
didn't see that.
Because it is categorically mentioned how it is.
No, I will look definitely. My lord, here it says, as regard the statement made in para 17 of the writ petition, deponent beg to submit that after amendment of the product on request of the bidders unknown in the GEM, the petitioner has not uploaded mandatory WH PQF certificate while submitting tender. I will look into that. Your lordship has said, what is the guideline that has been in the GEM portal?
Whether it will change the terms.
Yes. Now, whether your lordship is right.
If it does not change the term, then nothing remains. Their problem is solved. If it changes the problem, then the question is, What is to be
Government-
next question is to be done,
My
because
point-
you want the same thing which he is going to give you.
Chip.
Yeah.
We have, but we have.
You
these
also
technical-
produce the sponsorship, how it is being given. You must be getting some letter from the government of India to produce it on the next.
Okay.
That letter, because that letter will also give you a clear indication how it is. Will help. If
The
it is
government
not
of-
there, you can bring it by way of a short affidavit. If it is not there,
Okay.
let it be brought on record, because you never know, later on many challenges happens. You
What problem
have
is that?
councils like Mr. Das on the other side, so.
My lord, what they said, suppose you want to change it, what they said, any clauses incorporated by the buyer, they are the buyer, regarding following shall be treated as null and void, would not be considered a part of the bid. Any changes, and suppose you do it, then you have to take permission from the government of India. That your ultimate said that what is the stand, they have to take permission from government of India.
Because the
Yes.
government of India, if they have mandated that,
Why? They mandated,
so this automatically would not have amount to change.
yes, if it is
So the
mandated,
basis on which they want to call for a tender is gone. This is how one has to do. This is how these are various ways to look.
your lordship looks into it, commercial terms at page 83, 1.6.
So that I have heard it for making it part of now.
Cold chain can be tested, may be tested at ISO 1705 accredited laboratories.
Heard Mr. D. Das, the Learned Counsel, Senior Counsel, assisted by so-and-so appearing on behalf. And Ms. Emily Pottery, the Learned Planning Council of the Ethical and Husbandry Department of the government. The issue involved in the instant petition is the move made by the respondent authorities to cancel the tender wherein the petitioner herein is the highest bidder.
Yes.
Because this court have duly heard the learned counsels appearing on behalf of the
lowest.
parties at length. This matter. However, the hearing remains inconclusive on account of a document, on account of the non-availability of the document pertaining to the central government sponsoring the procurement,
Yes.
as well as the guidelines of the GEM.
Yes, sir.
This matter again on 18th of December 2012 at 2 p.m.
Yes.
and
But-
shown as part of.
But they have shown, my lord, this ISO / WHO.
That is what I'm
Slash.
saying. So their basic question is, look here, because of this, we made that particular comment. That we have made that particular comment, so it changes.
But they cannot change the ISO. They are saying WHO is mandatory. That is why the query which was put forward on the basis, but they changed that WHO is only, that ISO is gone. That is our case, my lord. And they cannot go beyond the central government, the advisory nature, what they have in ISO is mandatory. What they have said, they changed to WHO. That's the
No,
whole.
their
problem.
basic simple case is, look here, we want either the ISO or WHO, either of it. But when there was a comment being made out there in the portal, we made it very clear WHO. And when we made it WHO, thereupon, when the tenders were accepted, it was duly accepted. Some who were ISO, some who were WHO. And later on, we realized that no, we want both. But it would lead to certain complications, so we are cancelling and going for a fresh. Isn't it? Simple case.
Only problem is the time period. It's a central government fund and it will return till.
Therefore, we dispose it of.
Ultimately, in their affidavit, they realized, and they said, yes, we should have gone to option. That's their own stand. And those three unsuccessful
No,
bidders.
if it was taken up earlier, I would have finished it off now itself. But I don't have the time now.
Yes, sir, it's okay, my lord. Deeply obliged.
Item 27.
Oh, Mr. Banik, you're withdrawing? Huh?
Otherwise, those the observations which might come. This is not a case where it should come. I can argue a different case. Why take this burden for another case?
Because you see, 49L is there. As regards a dispute which can go before the registrar, whatever may be. But that cannot take away the power of the board under 38(2).
What I would have addressed, as I see it, I concede to the point that 49(2)L is only in a dispute, not when I'm thinking of shunting you out. If I want to remove you, I can just do it by 38. But 49(2) said, I want to keep you as a secretary, but I have a dispute of opinion, maybe, certain issues. I can refer to the registrar, maybe, it's just a hypothetical situation, but exercise of power under the statute cannot be arbitrary.
No, 49(2)B,
I
may,
mean,
no,
49(2).
49(2)B is a case which may arise that in a resolution which was adopted, which required, it may be an ordinary resolution, you require a quorum, the quorum was not there. So that resolution is useless, so 49(2)B comes into. Till it is there. But the moment they have a resolution tomorrow with a proper quorum, you're gone.
But to have a resolution, there must be an agenda. And if the agenda is about removal of someone, law does not allow arbitrary decisions or actions by persons who are brought in power by democratic process. The board of directors are elected members who come into the process by democratic process. Now, the law, as I see it, that cannot permit them to be dictators. It has to be in a way in the same flow because you're adopting a resolution. If you adopt a resolution, jolly well put that person to notice at least what you're doing. All my case was in this case is that the BOD had the board of directors having lost their jurisdiction under the sweep of 39, 2 consecutive years not being held. They had no jurisdiction to issue the notice. It's a different case altogether. New AGM has, new body has
No, you have not been removed.
have not been removed, but their action at that point of time with otherwise.
That is okay, but now in view of the new board coming in, they would be at liberty to take whatever action is there
But I withdraw the writ petition,
as per law. Huh?
I withdraw the writ petition. That was that observation.
Mr. Esbonik, the learned counsel.
As the new body has formed.
Huh?
Lordship may be pleased to observe.
I'll say. Mr. Esbonik, the learned counsel appearing on behalf of the petitioner submits that in view of the instructions, in view of the formation of a new board, of the new board, in view of the formation of the new board of directors of the formation of the new board of directors of the Nayar Olga Samabhai Samiti Limited, Bilasipara. The petitioner would not like to press the instant petition. Accordingly, the petition stands closed, interim order stands vacated.
Grateful.
Yes, why everybody is waiting for long? Nothing. Others may go, others may go. I have no time.